afternoon.
Good afternoon, Judge.
Good afternoon.
And Your Honor.
Quite a crowd we have here for just this sort of one case. Okay, first of all, let me start by saying thank you very much for your understanding. I'm presiding this week and have just run into some delays here and there in terms of my ability to manage my schedule for the day. So I really appreciate this many people's willingness and ability to accommodate me and to move things back to 3 o'clock. So thank you very much. Couple of things. Is this being taken down?
Yes, it is.
Okay.
Yes.
So, Madam Court Reporter, for your benefit, I'm going to call this case. It's actually two cases. We have Alexandra Hart, MD, individually and derivatively on behalf of the Plastic Surgery Group of Atlanta versus John Connors, MD, and the Plastic Surgery Group of Atlanta, case number 25 SC 13468. And then we also have Dr. Connors and the Plastic Surgery Group, Alexandra Hart, the Plastic Surgery Institute, Alexandra Hart Plastic Surgery, Tammy Parker, Lisa Garvey, etc. And that is case number 25 CV 014358. So I believe I've seen some email traffic about the beginning of this case about consolidation in practice, if not formally. Obviously, these cases, I believe, have been to some extent consolidated, but I don't know as we sit here now under which case number. And so I would like for everyone to address that issue for me and to start with counsel for Mr. Connors, so I can start figuring out who's who, and find out what you believe the status to be, whoever is going to be representing Mr. Connors.
Yes, Your Honor. This is Andre Hendrick with Holland and Knight. With me is Nick Leiskin. He's my colleague at Holland and Knight as well. We represent Dr. Connors and Plastic Surgery Group of Atlanta, PC. And I believe the court has entered an order consolidating the cases. The consolidation order provided that we would be traveling under civil action file number 25 CV 013468. So I believe at this point, everything has been formally consolidated into one case, and we have identified the case number under which we will be traveling moving forward.
Thank you very much, Mr. Hendrick. And who do I have on behalf of Dr. Hart?
Your Honor, I'm Bill Piercy, and with me are my colleagues Jeremy Kahn and Alyssa Gill.
And what about the other Jane Does and Tammy Parkers and Lisa Garveys and Jennifer Azars, etc., who are named in Dr. O'Connor's suit?
Your Honor, this is Jordan Foreman here for Tammy Parker and Lisa Garvey. And I have with me Brittany Brown. We're at Fox Rothschild.
And Your Honor, my name is Alex Bartko, and I represent Jennifer Azar, who is also here today.
Hang on. Mr. Bartko is who said they were representing Miss Azar?
Yes, Your Honor.
Thank you. And Mr. Foreman, you are representing Ms. Garvey and Ms. Parker, correct?
That's correct, Your Honor.
Okay. Anyone else that I've not named? Okay. Okay, so what I have, I originally received, I think, dueling orders seeking a temporary restraining order or interlocutory relief of some sort, and also at some point a request for appointment of a receiver. I've also received a motion to supplement or amend one of the complaints, and I've also received a motion to dismiss. Where Starting with counsel for for Dr. Hart, Mr. Piercy, where do you think it would make sense for us to start on that laundry list of motions?
Sure, I think the motions filed before December 19th, as the notice indicates, would be the competing motions for equitable relief, as well as various motions to dismiss. I think it might make sense to address the interlocutory motions first, and then to take the motions to dismiss from there.
Okay. What are your thoughts on that, Mr. Hendrick?
That's fine, Your Honor.
Okay. Any opinion on who gets to go first?
I mean, certainly Dr. Hart's was first filed.
Okay. That would be typically what I would do, is just go with the one that was first filed. And so, Mr. Piercy, that means you drew the short straw. So go ahead, sir.
Thank you, Your Honor. This case arises from the dissolution of a business relationship between Dr. Hart and her former business partner, Dr. Connors. Together, Hart and Connors own Plastic Surgery Group of Atlanta, PC, with each holding 50% of the outstanding shares. PSGA is located in the Avalon mixed-use development on Old Milton Parkway in Alpharetta. In September 2025, Dr. Connors terminated Dr. Hart's employment with PSGA. Dr. Connors claims that Dr. Hart's termination results in the forfeiture of her entire ownership in PSGA to him. It was in response to this pretextual termination that Dr. Hart filed this lawsuit. There's no basis for Dr. Hart to be terminated for cause, and she seeks injunctive relief and the appointment of a receiver to preserve the status quo until further order of the court. And so with that overview, a little background. Dr. Hart finished her medical residency and began working with PSGA as a surgeon in 2020. By 2024, Dr. Connors was sufficiently comfortable with Dr. Hart that he invited her to become his first and only business partner, offering to sell her 50% of the practice. Hart and Connors came to terms. They entered into a share purchase agreement, which is attached to Dr. Connors' counterclaim as Exhibit 1, a shareholders agreement attached to the complaint as Exhibit 1. Dr. Hart signed an employment agreement, complaint Exhibit 2, and they have a shareholders compensation plan, which is complaint Exhibit 3. Dr. Hart also guaranteed both PSGA's office lease at the Avalon and its line of credit with First Citizen Bank. To date, Dr. Hart has paid Dr. Connors more than $180,000 for her PSGA shares. Now, after becoming a shareholder, Dr. Hart began to attend regular meetings with Dr. Connors and PSGA's accountant and a practice consultant. They discussed finances and cash flow and operations. The more Dr. Hart learned about the finances of PSGA, the more concerned she became.
Mr. Piercy, let me ask
Yes.
you a quick question just to clarify.
Yes.
Contribution that you just identified by Ms. Hart, is that actual external funds contribution, or is that contribution in the form of revenue or deferred compensation?
So the $180,000 is a lump sum payment at closing. She signed a promissory note, but then paid that off. And then while she worked there, her draw was reduced each month by $10,600. Dr. Connors' draw was increased by a corresponding amount. That's actual dollars.
So a
spent.
combination of both then. Thank you.
All right. one of the things that Dr. Hart learned was that PSGA was making significant cash transfers to two other entities owned by Dr. Connors, but in which neither PSGA nor Dr. Hart hold any ownership. And those entities are C4 Surgical LLC and Big Green Assets Holding LLC. Both C4 and Big Green operate out of a building known as Avalon Medical Center on Parkwood Circle in Alpharetta. The Avalon Park Medical Center building is about 2 miles from the Avalon, the mixed-use development where PSGA has its main office. So 2 Avalon locations in this case. C4 operates an ambulatory surgical center, and Big Green holds equipment and assets that are used in conjunction with C4's operations.
Like medical equipment or buildings?
So there's a building, there's some equipment, both. All right. PSGA contracts with C4 to use its surgical center, and it contracts with Big Green to use assets and space. But the amount that Dr. Connors is causing PSGA to send to C4 and Big Green far exceed that for which any contract exists. As of September 2025, Big Green owed PSGA more than $127,000, and C4 owed Big Green more than $300,000. These balances are reflected on the PSGA balance sheet that's attached to Dr. Hart's first affidavit as Exhibit B. Now, in working with the accountants and the consultants, Dr. Hart also learned that Dr. Connors caused assets valued at more than $200,000, including a laser used in liposuction treatments, to be transferred from PSGA to C4, but without PSGA getting anything in return. That transfer document is attached to Dart's, reflecting that from PSGA's accounting records is attached to Dr. Hart's affidavit as Exhibit D. Dr. Hart learned during these meetings that Dr. Connors was double dipping in connection with her buy-in. Specifically, we talked about this a minute ago, Dr. Hart's draw is reduced each month by $10,600. Dr. Connors' draw is increased each month by $10,600. She knew about this. But it was when she started looking at the documents and asking hard questions, she learned that Dr. Connors was getting another $10,600 each month, effectively paying himself twice in connection with her buy-in. Now, all of these transactions expressly violate the terms of the shareholders agreement, Complaint Exhibit 1. Section 9E of that shareholders agreement requires that any expenditure in excess of $10,000 have the express approval of at least 2/3 of the shareholders. Dr. Hart holds more than 1/3 of the company, so she gets a vote, but she didn't. She was denied that opportunity. Throughout the summer of 2025, Dr. Hart tried to have repeated conversations with Dr. Connors about the assets being transferred, about the significant money owed by these other entities back to the practice, the double payments that Dr. Connors was receiving. He either wouldn't talk to her or got defensive, but it wasn't a productive conversation. This is important to Dr. Hart because she bought in with those assets, that cash, that laser, all being part of the practice. Now they're not. So her ownership interest, the value of those shares is diminished, and other assets owned by Dr. Connors are increased. So in September 12, 2025, I wrote a letter to Dr. Connors outlining Dr. Hart's concerns and proposing an orderly windup of their business relationship. That letter is attached to the complaint as Exhibit 4. That same day, September 12th, Dr. Connors terminated Tammy Parker's employment with PSGA, longtime employee, fired her that day. 5 days later, September 17th, I get a letter from Mr. Hendrick advising that Dr. Hart's employment with PSGA was terminated for cause. And that letter is attached to the complaint as Exhibit 5. The purported cause for which Dr. Hart was terminated are that she solicited employees to come work for her, that she solicited employees to serve her interests, that she double booked time at 2 surgery centers for patients and for procedures, that she disrupted the day-to-day affairs of PSGA, and that she intimidated those PSGA employees that she didn't try to solicit. Now, Dr. Hart did double book some medical procedures. She did that because Dr. Connors was threatening to cancel the surgeries that Dr. Hart had scheduled at C4, the Avalon Medical Center. Dr. Hart wanted to make sure that she could serve her patients and perform these procedures somewhere. So for a brief period, she had some double bookings at alternative locations. When she got that.
By double booking, Mr. Piercy, you mean that a patient is scheduled for surgery and Dr. Hart has scheduled that surgery to take place both at the C4 Surgical Center and then perhaps at another surgical center?
That's exactly right.
Okay, thank you.
And she got that figured out. She can't dealt with, nothing was double booked by September 17th when we received the termination letter. But more importantly than all this talk about double booking, none of the conduct that Dr. Connors accuses Dr. Hart of gives rise to a for-cause termination, because that's defined. It's in section 17C of Dr. Hart's employment agreement, complaint exhibit 2. There's a bunch of criteria that could constitute cause to terminate employment. And the provision lists things like losing her medical license or privileges at a hospital, filing for bankruptcy, getting convicted of a felony, becoming chemically dependent. There are some other things listed there too, but those things have a 15-day cure period associated with them. And some of those are breaching the shareholders agreement, breaching the employment agreement, failing to comply with reasonable policies of the practice. Those could give rise to a for-cause termination if not cured after notice is given for 15 days. Now, the termination letter that Dr. Connors sent doesn't say that Dr. Hart will be terminated if she doesn't cure. It says she shall be terminated in 15 days. Dr. Connors made it clear that the termination was happening, and there was nothing that Dr. Hart could do about it. So I want to talk for a minute about the restrictive covenants in the shareholders agreement. Connors alleges that Hart violated those provisions and that these violations give further grounds to terminate her employment for cause. First and foremost, as confirmed by Dr. Hart's affidavit, on her last day of employment at PSGA, September 30, 2025, she returned all PSGA property in her possession. Dr. Hart has not engaged in competitive activities within 10 miles of PSGA. Dr. Hart does not employ or otherwise work with any former PSGA employee who lives within 10 miles of PSGA. And Dr. Hart has not solicited any patient of PSGA who lives within 10 miles of that practice. That's first. Second, the alleged breaches of the restrictive covenants in the shareholders agreement, it's sections 21 through 23, they cannot form the basis for a for-cause termination. That's because all of the restrictive covenants in that shareholders agreement are post-term covenants. By their express language, the covenants only come into effect after Dr. Hart is no longer an employee. And the non-competition covenant is even more conditional. It only comes into effect if either a shareholder resigns from her employment, she didn't resign, she was fired, or her employment was terminated for cause. If the shareholder's employment is not terminated for cause, but for other reasons, the non-competition provision doesn't even apply. Express term of the contract. So whether Dr. Hart's termination was for cause or not for cause is important. And that's because the price at which either the practice or Dr. Connors must pay Dr. Hart to redeem her ownership interest in the practice, the formula is different whether the termination was for cause or not for cause. And that's why Dr. Connors strains to squeeze the round peg allegations of Dr. Hart's alleged conduct into the square holes of a for-cause termination as set out in 17C of the employment agreement. Connors has since doubled down on the for-cause determination and the consequences of it. He sent Dr. Hart a proposed stock interest assignment and bill of sale on October 6th. That document would effectively forfeit her interest for $0. It's attached to Dr. Connors' response in opposition to Dr. Hart's motion for injunctive relief as Exhibit 13. Although Dr. Connors insists that Dr. Hart must sign over her interest in the practice for nothing, he refuses to comply with the obligations imposed on him post-termination by that shareholders agreement. Paragraph 13 says that the remaining shareholders, that's Dr. Connor, must personally guarantee the departing shareholders' obligations on behalf of the practice, including the guarantee of the Avalon lease and including the guarantee of the line of credit. So, pursuant to that provision, September 23rd, I sent Mr. Hendrick a proposed guarantee agreement for Dr. Connors to sign. That's attached to the complaint as Exhibit 6. It's not been signed. It's not been returned. He didn't do it. Then in December, Dr. Hart received an email from First Citizens Bank indicating that PSGA wasn't paying its bills on time. There's an outstanding balance on a credit card of more than $160,000, and the payments weren't being made. Statements reflecting that are attached to Dr. Hart's affidavit, first affidavit, as Exhibits F and H. Unfortunately, Dr. Hart received another one of those notices just within the past week or so. Dr. Connors did not secure Dr. Hart's consent to transactions in excess of $10,000 as required by Section 9E of the Shareholders Agreement. He's transferred PSGA money to entities that he owns, but nobody else has a piece of, for no consideration. He's transferred equipment, including that laser, to C4 and got nothing in return. He's double paying himself by way of the draw that I described. PSGA has hundreds of thousands of dollars in outstanding debt, much of which Dr. Hart is a guarantor of. She has no visibility into the practice's finances or operations, despite being a shareholder, a guarantor. Dr. Hart is very concerned that she could be on the hook for PSGA's debts without recourse. Now, Dr. Connors would like you to believe that he can do whatever he wants with PSGA because Dr. Hart's no longer a shareholder. But that can't be right. The shareholders agreement sets out a procedure for the mandatory buyback of shares when a shareholder's employment is terminated. And regardless whether that employment was terminated for cause or not for cause, doesn't matter. Section B of both Section 4, the cause termination, and Section 5, the cause termination, had the same procedure. Within 30 days of termination, evaluation is supposed to be performed, a closing conducted, and a promissory note executed. None of that happened. Further, Section 13 says remaining shareholders, you got to sign a guarantor of the departing shareholders' obligations. That hasn't happened either. None of that has happened. None of the procedures have been followed. She's still an owner. She disputes the characterization for termination as being for cause, and she has legitimate concerns about the continued finances and well-being of this company. The more the company's assets are preserved or hopefully increased by collecting on some of these debts that these insider entities and people owe to the company, that is going to increase the value of her shares and ergo increase the amount by which she would be purchased, those shares would be purchased from her. So for all those reasons, she seeks interim equitable relief.
And what exactly is the scope of the interim equitable relief that she is seeking?
Yes, Your Honor. The appointment of a receiver to review, approve, and pay expenditures in excess of $10,000 on behalf of PSGA. A receiver to undertake to recover outstanding balances owed to PSGA by C4 and Big Green, and to ensure that Dr. Connors is not paying himself more than that to which he is entitled. And I don't know whether this would be in addition to or instead of that, but effectively enjoining Dr. Connors from making expenditures on behalf of the company or sending any money in excess of $10,000 without Dr. Hart's approval. At least the opportunity to vote on it, and enjoining him from sending money to C4 or Big Green outside the terms of the expressed agreements, written agreements between those entities. That's the relief, Your Honor. Thank you.
Thank you, sir. Mr. Hendrick?
Yes, Your Honor. All right.
Before you get started, I do just logistically, the mail at our courthouse is very slow. It gets there and then it sits in a mail room for Lord only knows how long. And so I'm looking at a document that was filed December the 17th for which you requested permission to file under seal. So I just want to let you know that I do have that in my hands. For future reference, to the extent that the parties will, I would imagine, require the ability to file things under seal, it might work best to email those things to me, and then I'll give you an order that you can send directly to the clerk for filing rather than mailing it to me, just to save you some trouble. But anyway, go ahead, Mr. Hendrick.
Thank you, Your Honor. And I think that I would like to start by addressing some of the factual allegations that were stated. And I guess that may be more acute Mr. Lyskin, who may be sharing some documents on the screen, as far as where I'll be starting, because the overarching narrative that Dr. Hart is attempting to weave is that Dr. Connors hid relevant financial information from her, that she was not given access to the books, that she recently uncovered this information, that she raised these issues with Dr. Connors, and when he was confronted with it, he got very upset, that he terminated her for cause out of the blue for questioning him about the company's finances, and that she was then forced to rush into court to seek, among other things, emergency injunctive relief. And that's not what happened. And it's not what the evidence shows. And Your Honor, what I would like to start with is some of the documents that were attached to the agreement to purchase of sale of stock, which is filed before the court. So it's in the court's record, and we're going to share parts of it on the screen so that you can see the pertinent parts, Your Honor. And what I will represent to the court is that as part of this purchase and sale agreement, Dr. Hart was provided access to financials for PSGA. She was represented by counsel. This was a months-long process, and all of this was thoroughly reviewed. And so, Nick, if you could bring up the balance sheet as of December 31st, 2023. So this is part of the financial information that was provided to Dr. Hart that she had to review in connection with her purchase of stock. And this was a balance sheet for PSGA that was provided to Dr. Hart at that time. And Nick, if you would start with the intercompany loans that were identified on this balance sheet. And so, Your Honor, we have highlighted on this, as you can see, the balance sheet dated as of December 31st, 2023 shows an intercompany loan between PSGA and Big Green Asset, where Big Green Asset owes PSGA approximately $160,884.93. And then right below it, you see an intercompany loan where PSGA is owed $2,543.94 from C4. Much has also been made about credit card bills. If you look at the same balance sheet from December 31st, 2023, it shows that there is a credit card bill, the Visa, in the amount of $87,733.02. And there was an Amex in the amount of $200,707.48. And so, Nick, I would also like you to now go to the balance sheet as of June 30th, 2024. This balance sheet was also part of the documents that were included in the agreement to purchase of sale of stock dated July 1st, 2024. So this is all information that was provided to Dr. Hart and was included in this closing package. And Nick, please go to the intercompany loans for that June 30, 2024. And you can see here that the intercompany loans identified show that $128,621.12 is showed as being due from Big Green to PSGA, and that $72,774.63 was owed to PSGA from C4 Surgical. And then, Nick, if you would go to the credit card bills that were shown on that same balance sheet. And you can see again, as of June 30th, 2024, there's an Amex bill of $151,224.29 and a Visa bill of $92,293.74. So at the time that Dr. Hart bought into PSGA, it had been disclosed to her that there were these intercompany loans between PSGA, Big Green, and C4. And Your Honor, I want to make sure that everyone is clear about the reality of this situation, because the way that it has been characterized by opposing counsel and by Dr. Hart in the pleadings is that this money is flying out the door from PSGA and going to C4 and Big Green for the enrichment of these companies and for the enrichment of Dr. Connors. And in practice, that is not what was actually happening.
And how do we know that, Mr. Hendrick? What financial documents could one look at to understand that that is not what's happening?
Well, Your Honor, and I'll have Nick pull something up in a second. Before I get to the documentary evidence showing this, what I would like to explain is kind of the evolution of this, which was known to Dr. Hart when Dr. Connors started the surgery center, which, if memory serves, it started early in either 23 or 24. When he started that, when he was talking with his accountants, at the time, Dr. Connors was the only shareholder. And what his accountants advised him, and I also want to keep in mind, Dr. Connors has always relied on professionals to guide his practice. He has an outside accounting firm, and he has an outside medical management company. And so he has relied upon advice from those individuals. And so one of the things his accountants informed him was that he would be better off from a negotiation standpoint when negotiating insurance benefits if there were more people. And so all of the employees for C4 and PSGA were all lumped together under the PSGA umbrella so that they could negotiate better rates for their insurance agreement, which inured to the benefit of everybody at C4 and PSGA. Okay. And so the same thing happened with certain technology. So you have EMR software that can be incredibly expensive. And this EMR software is utilized by both PSGA and by C4, which operates the ambulatory surgical center that is used by PSGA. It's in a separate building. It's the ASC. And so all of the employees, all of the people who work at the ambulatory surgery center, except for one 1099 independent contractors, are technically employees of PSGA. And the way that they have it set up is that there is an employee leaseback agreement between PSGA and C4. And that way, so PSGA is paying all of the employees. And then once Dr. Hart came on, in talking to their accountants, they said, well, because Dr. Hart does not have an ownership interest in C4 and Big Green, we need to start allocating some of these costs between Big Green, C4, and PSGA to make sure that these two companies that are owned exclusively by Dr. Connors are paying their fair share and PSGA is paying its fair share. And so these amounts that are showing up on as intercompany loans are due to this allocation of shared expenses, whether it is employees or insurance or use of technology. So that is the source of these intercompany loans, all of which was disclosed to Dr. Hart prior to her joining PSGA. And Dr. Hart regularly communicated with this medical management company. Nick, if you could bring up the email with MMA dated December 3rd, 2024. And Your Honor, what you'll see here is an email from Dr. Hart dated December 3rd, 2024. So this is December 3rd, 2024. Okay, more than a year ago. Dr. Hart sends an email to Maggie, who works at MMA, says, I wanted to follow up on the updated numbers for the quarter. And later that very same day, Maggie responds, and as part of that response, she mentions allocating expenses between C4 and BGA. She talks about the loans given to C4 and BGA. And Nick, if you would also continue down this, because there was an attachment. If you would go to the payroll report where it shows the impact of the leased employees. And so right here, Your Honor, Nick, if you'd scroll down just a little bit where you can see payroll, and at the very bottom in the left, you see C4 employees, payroll. So here is where you are seeing this allocation of the leased employees. Again, all of this information being shared with Dr. Hart by the medical management company. This is December of 2024. So the idea that all of the finances were being hidden from her it is disputed by this documentary evidence. And then, Nick, if you would pull up the May 26, 2025 email from Dr. Hart to Dr. Connors and Tammy Parker. And so this is an email from Dr. Hart. This is to Dr. Connors and Tammy Parker. And here Dr. Hart is saying she spent some time going through the entire QuickBooks for the last 6 months and then Sheets, and she made a template, and she even puts together some ideas about how they can try to pay some things back and reduce their debt. And so here you have ongoing conversations between Dr. Connors and Dr. Hart about these outstanding issues. This was all information that was on the table and well known to Dr. Hart. And then, Nick, if you would pull up the storage agreement between Big Green and PSGA. And Your Honor, this is the second iteration of this storage agreement. And this one was even signed by Dr. Hart on behalf of PSGA. This is a contractual agreement with Big Green that requires PSGA to make payments to Big Green. And like I said, this is the second iteration. This one was even signed by Dr. Hart. So the idea, this narrative that these things were hidden from Dr. Hart is just not factually accurate at all. And then there is this other narrative that is being thrown out there that in response that Mr. Piercy sent a letter to PSGA and Dr. Connors, and I believe he described it as trying to accomplish an orderly wind-up of the business. And that in response to that, and in response to this questioning about Dr. Hart, Dr. Connors just out of left field fires her for cause without any basis at all. And that is patently false. Leading up to that, Your Honor, there had been a lot of scuttlebutt around the office that Dr. Hart was planning to leave. She was going to start a competing practice and that she was going to be poaching several of the employees. And the one thing that Mr. Piercy omitted, Nick, if you would pull up the email between Dr. Hart and Maggie about her resignation. And so, Your Honor, one thing that was left out was the fact that before Dr. Connors terminated Dr. Hart for cause, Dr. Hart had already announced that she was leaving, that she was resigning and was trying to wrap up her practice. Here is an email from Dr. Hart to Maggie at MMA, who we've been looking at these emails, and here is Dr. Hart saying, Tammy was unexpectedly fired on Friday without my knowledge or consent while I was out of town. Additionally, it will be no surprise to you that I am leaving PSGA and will be working out my exit plan. I appreciate everything you have done for us. So this is days before, thank you, Nick. This is days before she was fired for cause. Dr. Hart was already telling people that she was quitting and leaving. And so this idea that Dr. Connors just flew off the handle and terminated her for cause for no reason, and that it was this huge shock and that she would still be here today but for that, is just completely unfounded. And in fact, what the facts show is that that was exactly what she was planning on doing. And when you look at the facts, days after she is fired for cause, Tammy Parker is reaching out, securing tail insurance coverage for her. She is opening a website. She has secured a new location. She's open for business. So this is someone who had a plan, and she was not going to be at PSGA. Okay.
But
Yes,
Mr.
Your Honor.
Hendrick, let me ask you this though. So what I have gotten so far, right, is that Dr. Hart alleges that Dr. Connors was not was engaging in some self-dealing with what she believes halfway belongs to her, right? And what I
Yes.
hear from you is that Dr. Hart had one foot out the door and that ultimately the relationship broke down because Dr. Connors realized that she was heading out the door and took actions to accommodate that, head that off, whatever, right? That's sort of where everything went south. Here's what I am interested in, though, that Mr. Piercy addressed that I've not heard a response from you, and I'm very interested is what, though, about the fact that Dr. Hart owns half of the practice, or at least owned half of the practice. And I think I understood Mr. Piercy to say that he believes Dr. Connor's position in this litigation is that by firing her, he deprived her of the value of the ownership that she had. Can you address that for me? What is her status relative to the practice, either because of or in spite of her termination?
And I thought we may get here at some time. Nick, if you would pull up our rundown on why Dr. Hart is no longer a shareholder, and we will go through this, Your Honor. And
A lot of titles in this conference.
Yes, there are. And I will tell you that one of the things that is so important here are the provisions in the governing documents. And the provisions in the governing documents are so important because the entire purpose for them is to prevent a situation that Dr. Hart is trying to create, which is you have a former shareholder, former employee who has now opened a competing business and who is trying to say, well, I'm going to stand over here and compete with you, but I'm also want control and to be able to meddle in how you are running these affairs because I'm going to take the position that I am still a shareholder. And so, Nick, what I would like you to pull up is the Dr. Hart's employment agreement, and I would like you to go to section 17C. And Your Honor, before I get into the nuts and bolts of this, one very high level point I would like to point out is this is a motion for injunctive relief. And what Mr. Piercy's argument was really focused on was the money that Dr. Hart is owed.
Sure, absolutely.
And that's what this.
Yeah, let me save you some trouble, Mr. Hendrick. I mean, even the question I just asked you now is really more about the substance of this case further down the line without the benefit of law on my part and without the benefit of fully developed facts through the process of discovery. I fully understand that. But as we sit here now trying to understand the basis for Dr. Hart's assertion, I mean, well, let me say this. Abstractly speaking, there's no dispute that Dr. Hart contributed some funds and was the owner at some point of half of this practice. And what Mr. Piercy has asserted is that she remains an owner of half of this business. And your position is that she does not. And that's what I'm trying to get to the bottom of in terms of for this preliminary posture of the case, determining what rights a putative owner might have to demand insight and or control by a third party over the operation of that business.
Understood, Your Honor. So here's where we start. And this is section 17C of Dr. Hart's employment agreement. And it lays out how the company can terminate for cause. And what it says right here is the corporation, with employee having no vote on behalf of corporation, whether by deadlock breaking or by veto power on this question. So what that says is Dr. Hart does not get a vote in whether or not she should be terminated for cause. And so because Dr. Connors is the only other shareholder in the company, he casts the sole vote as to whether she should be terminated for cause. He did that and decided that she needed to be terminated for cause.
On what basis? As I read that provision, it's if you're terminated for cause because of one of these things, then that's how the employee has no say in the corporation's decision. Which one of those is asserted? Again, I understand this is all very preliminary, but
Yes, and Nick, if you would scroll down, employee materially breaches this agreement or the shareholders agreement, and it's not cured within 15 days. Employee fails or refuses to faithfully and diligently perform the duties of employee's employment. There were several that employee engages in conduct amounting in the reasonable discretion of the corporation to medical malpractice, or employee behaves in such a manner that is unprofessional or is detrimental to the character and standing of the corporation. And such conduct or behavior is not cured by employee within the 15 days. And Your Honor, the principal issue that Dr. Connors was having with Dr. Hart was the fact that in addition to sowing discord in the office, in addition to being an incredibly divisive force, he was convinced, and it proved to be true, that she was actively planning to open a competing practice and poach his employees and go elsewhere. And he considered that conduct to be unprofessional, unethical, and detrimental to the character and standing of the corporation. And so it was on that basis that he terminated her. And there is evidence already that that was in fact true. And during discovery, we think there is going to be substantially more evidence, because it is hard to fathom that if she was not already planning and talking with people, that Tammy Parker would be reaching out about her tail insurance days later, that she would be soliciting patients, that she would have already located and secured space and be opening up for business. I will say that it is also, just from an optics perspective, you had the departure of Dr. Hart, Ms. Azar, Ms. Garvey, and Ms. Parker all within the same month, and is almost perfectly timed, or some of them could go on this weeks-long vacation to Italy in the interim between when they were right after they left and when they started the new business. When we were trying to serve Dr. Hart with this lawsuit, she had already secured a new space. That's how quickly she was already up and running in a new space, Your Honor. And so, you know, Dr. Connors was convinced that she was breaching her fiduciary duties in not only preparing to open a new business, but crossing the line and seeking to improperly solicit employees within the company. And Mr. Piercy has tried to draw this distinction that the restrictive covenants are post termination, but she still owed fiduciary duties to the company that included the utmost loyalty, transparency, honesty, duty to operate in good faith. And there are cases in Georgia which have held that you cross that line when you start soliciting employees, trying to recruit employees to go work for you at your new venture. And so, you know, on that good faith belief, which turned out to be true, we firmly believe turned out to be true, he terminated her for cause. And so that brings us to section 5A of the shareholders agreement. So Nick, if you could get us there. And so section 5A of the shareholders agreement says, upon termination of a shareholder's employment by the corporation for cause, pursuant to such shareholder's employment agreement with the corporation, or upon termination of a shareholder's employment with the corporation as a result of such shareholder's resignation from such employment. So either you resigned or you were terminated for cause, and we have evidence that she was already telling people she was quitting and she was terminated for cause, then the corporation shall have the option to purchase, and if such option is not exercised, then the remaining shareholders shall purchase, and the terminated resigning shareholder shall sell all of such terminated resigning shareholder stock in the corporation. So this was triggered by her termination for cause. It was also triggered by her announcement of resignation. Either way, the company would have had the right to purchase the stock. In fact, it says that they shall purchase and the terminated resigning shareholder shall sell. And so then that brings us, yes.
Right, the letter that I saw said that she requested Dr. Hart to sign a bill of sale for $0.
Yes, Your Honor. And Nick, if you can pull up the table, thank you. Your Honor, this is a table that was in the shareholders agreement. This is not something where Dr. Connors just said, I'm going to try to be punitive. I'm not going to give you any money. This is all determined by the shareholders agreement that Dr. Hart signed. And what it says is, if you are a shareholder for less than 5 years and you either compete with the corporation or you resign without giving at least 12 months notice, or you are terminated for cause, the applicable percentage that is utilized in determining the purchase amount of your shares is 0%. And so everything else that Mr. Piercy was just talking about as far as alleged transfer of assets, and which we dispute, but it is not really relevant. All of the other things that he was just talking about that allegedly would impact the value of her shares, it doesn't. It's irrelevant because she was a shareholder for less than 5 years and she either resigned without giving 12 months notice or she was terminated for cause. And so the applicable percentage that is utilized in this formula, and there's a bunch of other things that go into the formula, Your Honor, but to get to the end of it, doesn't matter what you multiply by 0, it's 0. And that is what the document, that's what the agreement says that Dr. Hart signed when she became a shareholder in the company.
So, Mr. Henry, let me,
Yes.
I feel like much of what you are discussing is still functionally a response to Mr. Piercy's presentation. And I don't want it to get lost in the shuffle that Dr. Connors has also filed a request for injunctive relief. And so I'd be curious, I assume it's associated with the restrictive covenants, but if you could please address that issue and tell me what it is that PSGA and Dr. Connors are seeking to restrain.
Yes, and Your Honor, I apologize. I thought that I was supposed to just be responding to their motion for injunctive relief.
No. I mean, you are and you were, but I also feel like the two matters are, besides the obvious, but they are inextricably intertwined in terms of, I feel like I have an understanding of your position at this preliminary stage regarding Dr. Hart's relative position to the practice for purposes of requesting injunctive relief. And so really that was more of just I think I've heard what I want to hear for now. Let's move on to your motion so I can then hear from Mr. Piercy.
Sure. And Nick, at this point, what I want to do is go to that portion of our outline on the motion for TRO that focuses on the key facts entitling Dr. Connors and PSGA to relief. And before you start popping documents up, Nick, I will start by, Your Honor, telling you exactly the injunctive relief we're seeking. And then we will go through the facts and the evidence that's before the court that we think warrants that relief. And Your Honor, here is the relief we are seeking. We are seeking an injunction preventing from Dr. Hart and or anyone acting on behalf of Dr. Hart or Dr. Hart's competing practices from soliciting any PSGA's employees who reside in the restricted territory, an injunction preventing Dr. Hart and or anyone acting on behalf of Dr. Hart or Dr. Hart's competing practices from soliciting any of PSGA's patients who reside in the restricted territory, an injunction preventing Dr. Hart, Parker, Azar, or Garvey, or anyone acting on behalf of Dr. Hart or Dr. Hart's competing practices, Parker, Azar, or Garvey, from using any of PSGA's confidential information, proprietary information, or trade secret information, and an order directing all of the, I'm just going to refer to them collectively as the Hart defendants, to make copies of all PSGA information and documents in their possession, turn it over to their attorneys for immediate production to Dr. Connors and PSGA, and confirmation of destruction of the same by the Hart defendants, with the understanding that a copy may be retained by counsel for the Hart defendants for use in this litigation only.
Okay, Mr. Hendrick, I have heard Mr. Piercy say that Dr. Hart hasn't done any of those things, right? Now, I feel like the confidential information is in a little bit of a different bucket, and so we're going to talk about that a little bit differently in a moment. But as an initial matter, I've heard Mr. Piercy say that there either is no evidence or that, in fact, Dr. Hart has not engaged in any behavior that would be violative of those restrictive covenants, particularly the solicitation of patients within that geographic area.
And so let's go through some of the evidence that we have already and understand, Your Honor, that we have conducted no discovery.
Of course.
So, I mean, the fact that we have any evidence at this point is, frankly, is lucky for us because, you know, it's stuff that we have come across, that Dr. Connors has come across. The evidence of this is really within Dr. Hart's possession, in Ms. Parker's possession, in the defendant's possession. And so, Nick, I want to start with the email from the patient stating that she received a message from Dr. Hart. If you could pull that email up. And so here's an email from a patient. We've redacted her name. And it was sent to Christy Hart, no relation to Dr. Hart. Christy Hart works at PSGA. And it says, "Good morning. I just received a message from Dr. Hart that she's no longer with the practice. Myself and my mommy makeover and my daughter has an earlobe surgery scheduled with her and payments pre-made. What is happening with the money I've paid up front, etc." What you can see is that she just received a message from Dr. Hart, okay? Then, Nick, if you'll pull up the transcription from the voicemail. So a patient, to give you just a quick thumbnail, a patient came to see Dr. Connors and played for him a voicemail on her phone from Dr. Hart. Dr. Connors took a video of the patient playing the voicemail. We have transcribed it. We'll provide it to the court if the court would like. But it says, "Hi, patient name. This is Dr. Alexandra Hart. I was just calling to let you know that I have left PSGA and started my own practice. And it's actually going to be in Sandy Springs, so I apologize if it is a little bit further for you. But if you wanted to continue, there was something inaudible, I wanted to make sure you had my number. My new office number is etc., and I look forward to seeing you soon. So here are two examples, and we've run down this recent one. But depending on how you drive there, I don't know. But by the way the crow flies, this last patient is within 10 miles, which is within the restricted area. But Your Honor, it also triggers more than just the non-solicitation. Because Nick, if you will pull up the patient provision that is in Dr. Hart's employment agreement. So Dr. Hart's employment agreement provides, has an entire provision just about patient records. And what it basically says is all of the patient records belong to PSGA. And if you're terminated, you've got to turn back to the corporation all of your patient records, period. Now, we had Dr. Connors confirm for us, he has not received any patient file transfer requests for any of the 10 people that we have already identified that we think may have been solicited by Dr. Hart. And so the question becomes, how does Dr. Hart have these people's cell phone numbers? She was supposed to turn back over all of her patient information, all of her patient files. There would be no way for her to be able to contact these people unless she took patient records that she was contractually obligated to turn back over. And patient identification is also considered, a customer list is considered trade secret under Georgia law. So what you're looking at here is this action by Dr. Hart actually implicates several different claims. You have a breach of her employment agreement. You have a possible breach of the restrictive covenants that are incorporated into her employment agreement, into the shareholders agreement. You have a trade secret, Georgia trade secret claim. So you have multiple claims, plus a breach of the confidential information provision that is included in her employment provision. So there are so many different claims that are triggered by just, this evidence. And in addition to the email, in addition to the voicemail, Dr. Connors and PSGA have received 6 pathology reports that have, two pathology reports that have accidentally been sent to PSGA regarding surgeries that have already taken place by Dr. Hart for former PSGA patients, and 6 confirmations for surgeries, upcoming surgeries for PSGA patients. Again, PSGA did not receive any patient file transfer requests for any of these people. So already we have evidence of 10 former PSGA patients that, provide evidence of possible claims against Dr. Hart. You have this email, you have the voicemail. There is a lot of evidence here that Dr. Hart is breaching contracts and committing business towards. And the difference here is there is actually a threat of irreparable harm here. And that is another very important distinction, Your Honor. It is well recognized under Georgia law that patient loss of customers, business goodwill, that is recognized as a loss of irreparable, that is irreparable harm. Now, if you look at Dr. Hart's motion for injunctive relief, Your Honor, they don't argue irreparable harm. In fact, they take the position that they do not have to prove irreparable harm. And in support of that, they cite 3 different cases. And this is significant because the cases they cite are Focus International Inc. versus Partridge Green, Parker versus Cleary Lakes Recreation Association, and Kinyard versus Ryman Farm Homeowners Association, Inc. Okay, those are the cases that Dr. Hart cites in the motion for interlocutory injunction saying we don't have to show irreparable harm. And if you read those cases, that's not really what those cases say. All three of those cases deal with real property. And what the courts say in those cases are when you are dealing with threatened injury to real property, because of the unique nature of it, irreparable harm is presumed as a matter of law. And so therefore, the party does not have the same obligation to establish irreparable harm, nor does the court have to make the sort of express findings about irreparable harm that you would normally expect to see. That is the exception to the rule. This case is not dealing with real property. And the rule which governs here, Your Honor, is that irreparable harm is the most important of the four factors that a court considers. And when you look at Dr. Hart's motion for equitable relief, they make a few conclusory statements about business goodwill. She's no longer, what goodwill are you talking about? PSGA? That's the only goodwill, and she's no longer a shareholder. In fact, she's actively competing against PSGA. So that, and if you look at that section, they do not cite to any evidence at all in support of the one or two conclusory statements about irreparable harm. Okay, and so they are completely lacking any sort of showing on the most important element for establishing, for being entitled to injunctive relief, which is irreparable harm. And when you listen to Mr. Piercy's argument, it's all about monetary damages. Dr. Hart's case comes down to these two things. She claims that she is owed money. She wore two hats at PSGA. One was as an employee, and there was a shareholders compensation plan. And she says that I am owed money as set forth in the calculation of the shareholders compensation plan. And she also says, in my other hat, I was a shareholder and I owned stock. And you redeemed my stock for $0. I claim that Dr. Hart claims that that PSGA should have had to pay her more than $0 for that stock. That is essentially her case in a nutshell, Your Honor. It's I am owed money as an employee, and I am owed money for my stock. You took my stock for $0 and you should have paid me money. You terminated me, and before I left, I deserved my final paycheck. And those are matters that PSGA disputes, and those are matters that the parties are entitled to conduct discovery about and that will be tried. And if Dr. Hart obtains a monetary judgment, she will be made whole. This is not a situation where money cannot make her whole. And there have been some conclusory allegations, Your Honor, about PSGA and not paying its bills and how they're on the brink of financial collapse. And so that's why we need to monitor this business. And Your Honor, I can tell you.
Let me save you some trouble there, right?
Yeah.
Which is that I am, other than the credit cards and the transfers to the other entity, the surgical center, et cetera, the fact that there is a third-party medical management group involved here gives the court some assurances that the types of self-dealing that sometimes can be engaged in by closely held practices, businesses, et cetera, is somewhat mitigated by the existence and presence of a medical management group. And so I don't know if any of the other issues are as easy, but I can tell you the one easy one is I have not heard anything here so far that would justify the appointment of a receiver. That doesn't mean I might not require some disclosure to Ms. Hart on a routine basis. We'll think about that, and I'm not ruling that right now. I'm just saying that, to your point, Mr. Hendrick, you don't have to persuade me on that point, because I agree that at this point, I don't think that Dr. Hart has established something that would rise to the level of a receiver, number one. And number two, I also think, to your point just a moment ago, that appointing a receiver at this point would be something akin to an effort at prejudgment attachment, and we're not going to go down that road just yet.
Thank you, Your Honor. The one thing I will say was that one of the reasons why we reached out about live testimony was if you had said today you were going to have it, someone from MMA was going to be sitting in the seat and trying to give the court exactly that comfort as far as the active level of engagement and transparency and how they oversee it. Dr. Connors is a very good surgeon. He's not trying to wear all the hats. And that's why he's always had an accounting firm. He uses a medical management group, and he defers to their judgment. And the things on the books are there because that somebody told them this is the right way to do it. And so, Your Honor, when we're talking about, I'll tell you where I was going to go, Your Honor, and if you would like me to head somewhere else, please let me know. I have gone through some of the evidence that we have about Dr. Hart and her conduct. There's some evidence I was going to go through with respect to some of the other individual defendants that we have in their conduct. If that is what you're along the lines of what you are thinking, I'm happy to go there. If not, I can go somewhere else.
Okay, couple things that I think would be helpful, but very high level on that point. Number one is, do these individuals, Ms. Azar, Ms. Parker, and Ms. Garvey, do they also have similarly written non-competes, or is the issue associated with them the alleged taking or use of confidential information?
Your Honor, it is limited to the taking and use of confidential information, which is why when I kind of went through, this is what we're asking for. It was different that when I got to the one that addressed confidential information, it included all of the Hart defendants, the non-solicitation of patients, the non-solicitation of employees. That was limited to Dr. Hart because she's the only person that has that restrictive covenant.
Okay, and the one other piece of clarification I would like is, I believe I saw an email communication that you showed to me at some point that Ms. Parker was terminated. Does that by inference indicate that Ms. Garvey and Ms. Azar were left voluntarily?
Yes, that is correct. Both of them left. I think pretty much everybody left at right about the same time, Your Honor.
Right, but
Yes,
that
voluntarily.
point that
Voluntarily.
Parker was terminated.
Correct.
As opposed to having left voluntarily, although I'm assuming the implication from you is that she was terminated because you, Dr. Connors and the group believed that Ms. Parker was or had been assisting Dr. Hart.
Yes, Your Honor.
Okay. Okay.
In addition to other things, yes. Yes.
Okay.
And as far as Ms. Parker is concerned, what some of the evidence we were going to put on, if you allowed for live evidence, was that she wiped her computer, like deleted everything on her computer before she left. There are two cases where I have found. One is Fugarino versus State, 243 Georgia App 268. It's a 2000 decision where the court found that deleting information prior to an exit violated the Georgia Computer Systems Protection Act. And DUCOM, D-U-C-O-M versus State, 288 Georgia App 555, found that copying information for use in a future competing business also violated the Georgia Computer Systems Protection Act. Also, on the way out of the door, Ms. Parker said that Dr. Connors was going to go bankrupt after Dr. Hart left. I would note that she was terminated before Dr. Hart was terminated. So this just kind of shows you everybody knew Dr. Hart was out the door. And certainly Ms. Parker did. And then on September 18th, so this is the day after we terminated Ms. Hart, only 6 days after we terminated Ms. Parker. Ms. Parker contacted PSGA's insurance provider about obtaining tail coverage for Dr. Hart. Nick, if you could pull up that email. And so this is Michaela Nolan, who works for the same insurance provider as PSGA, who reached out to, it eventually got to PSGA, but on September 18th, Michaela gets a call from Tammy Parker, who's reaching out on behalf of Dr. Hart, trying to secure tail insurance. And as I said, this is the day after Dr. Hart's been terminated for cause by PSGA, 6 days after Ms. Parker was terminated. And then Nick, if you'll pull up the September 23rd, 2025 email about Ms. Parker's, here we go. So Ms. Parker was terminated, as I said, on September the 12th. And here we received an email. It was an automatic email that was sent to Tammy Parker's PSGA work email address from Aetna. Excuse me, this is September 23rd. That says confirming that a user with Tammy Parker's PSGA email address had just accessed and been granted access to the Aetna portal, which contains confidential information regarding PSGA's employees. And then Nick, if you would go to the October 13th, 2025 automated email. And this is another similar automated email that was sent to Tammy Parker's PSGA email from Revance, which is PSGA's pharmaceutical company portal. And here it's saying, we received your request to reset your Revance Ready password. So somebody using Tammy Parker's PSGA email account is trying to access PSGA's information. This is after she has been terminated. And then Nick, if you would bring up the October 9 social media post, because that there has been this kind of playing fast and loose with whether or not Tammy Parker works for Dr. Hart. And what people are saying is that it doesn't count because Dr. Hart has hired Tammy Parker's consulting company. And so she's not really working for Dr. Hart. She's working for Dr. Hart's, Dr. Hart didn't hire Tammy Parker. She hired Tammy Parker's consulting company. And so
Right.
therefore, she didn't solicit her, she solicited her consulting company. And I'll say that the non-solicitation provision in the shareholders agreement talks about employment directly or indirectly. It is broad. And I think that this sort of conduct would also still constitute a breach of fiduciary duty if she was recruiting her and or her consulting company while they were still employed at PSGA. And again, this is October 9th. So you're talking about less than a month after Tammy Parker was fired. And keep in mind that in the interim, after PSGA sent this termination for cause to Dr. Hart on September 17th, shortly thereafter, she went on a 2 or 3 week Italian vacation. And by October 9th, she's already up and running and is assembling her team or has her team assembled. And then Nick, if you'll pull up the December 16, 2025 social posting, this just again shows, this is Dr. Hart posting, big thanks to Tammy Parker. So this, legal fiction about her not working for Dr. Hart, I think is disputed by these posts, the emails, all of the evidence before the court. And so when you're talking about what claims are implicated here, you've got, this certainly supports claims against Dr. Hart for breach of fiduciary duty, against Ms. Parker for aiding and abetting a breach of fiduciary duty, violation of the Georgia Trade Secrets Act, violation of the Georgia Computer Systems Protection Act, conspiracy. And there's been this preemption argument, Your Honor, between the Georgia Trade Secrets Act and the Georgia Computer Systems Protection Act. And they have to be based on the exact same facts. It's basically saying you're not allowed to double dip.
Let me stop you there.
Yeah.
I don't have to decide that issue today. That is an
Okay.
issue for a much more detailed briefing, and I don't want to go down that particular rabbit hole today, Mr. Hendrick.
Okay. I'm not going to much time with Jennifer Azar. The one thing that I will point out is that in her response and in her affidavit, that was served in response to PSGA and Dr. Connor's motion for interlocutory injunction. She confirms that she took pictures of PSGA's patient information and that she still has that patient information. That alone, Your Honor, we're not trying to be overly punitive, but we think an injunction there would be warranted to prevent her from using any of that confidential information, disclosing any of the confidential information. We'd like it provided to her attorney. They can make a copy, produce it to us. Ms. Azar can destroy it, confirm that she's destroyed it. Like I said, we're not asking for anything over the top there. We're just trying to make sure that there is a level playing field as far as competition is concerned moving forward, and that nobody out there has our stuff. Just
Understood.
very simply, we want our stuff back, and we don't want any of them using our stuff.
Okay.
And so, Your Honor, and with respect to Ms. Garvey, I'll be very straightforward. Without the benefit of discovery, Ms. Garvey left at the exact same time. She was part of this tightly knit group of people. My understanding is that she's not working directly for Dr. Hart. Without the benefit of discovery, I'm not going to misrepresent anything to the court about the role that she may or may not have played in this. We don't know until we are able to conduct more discovery into this. We would ask that the injunction include her, just to say the same thing as Ms. Azar. Basically, if you have any of PSGA's stuff, you need to turn it over to your attorney. They'll take a copy of it, produce it, and she has to confirm that she's destroyed it. And that is the extent of the injunction that we would ask that would be entered against Ms. Garvey.
Okay.
And I've been talking a long time. I've got many pages, but if you don't have any questions about any of, with respect to our response to Dr. Hart's motion for injunctive relief or equitable relief, or our motion, I'll give somebody else a chance to talk.
I think you have covered the waterfront, Mr. Hendrick, and I appreciate that. So before I hear from Mr. Piercy in response, I do want to just briefly find out if Mr. Foreman or Mr. Bartko have anything to add in terms of a response to anything that we've just heard. Start with Mr. Foreman.
Thank you, Your Honor. And yes, I definitely do have a few things to say, but I'll try and keep it brief because, again, I think, and you'll see this very quickly, our position is that my clients, and Mr. Barker, I can't speak for him, but probably feels the same way, are tangential to this whole thing. And frankly, we're surprised that they were even named as parties. Everybody knows that. That's why we filed a motion to dismiss. I'm going to take each one of my two clients in turn, and I'm going to actually go in the reverse order of Mr. Hendrick. I'm going to start with Ms. Garvey. And you heard what Mr. Hendrick just said a minute ago. He has no direct evidence that Ms. Garvey is working with Dr. Hart. In fact, and one of the things that we filed in response to as exhibits to our response in opposition to the TR for both Ms. Parker and Ms. Garvey were their affidavits. And we'll get to Ms. Parker in a minute and Mr. Hendrick's contention that he thinks we're parsing it a little too fine in terms of the competition. But with respect to Ms. Garvey, she stated in her affidavit, and the evidence would absolutely show that she is not working with with Dr. Hart in any way. Timing of her resignation, and mind you, she's the only one of the three of them that did resign. I mean, you've heard even Mr. Hendrick say Ms. Parker was terminated. Dr. Hart was terminated. We heard that from both Mr. Piercy and Mr. Hendrick. Ms. Garvey resigned, and she basically tells you exactly why she resigned in her affidavit. And I don't mean to oversimplify it, but it wasn't fun to work there anymore, Your Honor, because, Ms. Parker wasn't there. Dr. Hart wasn't there. There'd been a lot of, obviously, it had been a very tense situation with everybody, including Dr. Connors, and the whole dispute with Dr. Hart, Ms. Parker's sudden termination. And so she didn't want to stay there anymore. And this is a right to work state. She doesn't have to stay there. that offers not a shred of evidence that she went to work for Dr. Hart in any way, shape, or form. Not her, not any company that would purportedly be owned by her, and isn't working for any company involved in any way, shape, or form with either Dr. Connors or Dr. Hart. And she
Well,
addresses,
Mr.
yes,
Let me save you some trouble as well. Absent any evidence that Ms. Garvey has engaged in any theft of confidential information or use of confidential information that shouldn't be in her possession, which I believe, in fairness, Mr. Hendrick fully acknowledged at this preliminary stage. The court's not likely to enjoin her from doing something that there's no evidence she has done, and that the representations, the evidence currently does not indicate that she is in a position to do the thing that Mr. Hendrick and Dr. Connors would have me prohibit. So hopefully that makes it a little bit easier for you in that regard. Now, that doesn't mean that Ms. Garvey, from what is lawful and what might open her up to future injunctive relief and or further potential legal liability, shouldn't refrain from engaging in that behavior regardless.
absolutely, Your Honor. And
I'm not likely to enter an injunctive order against Ms. Garvey when, in good faith, Mr. Hendrick has acknowledged that while he has concerns that might be happening, he has no evidence that would indicate that it does, or that it has, or that she's in a position to have done it. So if you want to move on to Ms. Parker.
yeah, I'll quit while I'm ahead on Miss Garvey. That's fine, Your Honor.
Already winning, so you can stop selling.
All right, very good. Thank you, Your Honor. Appreciate it. With respect to Miss Parker, a couple of things. And again, I think it is significant that she was terminated. I think Mr. Hendrick, it was a little confusing on the dates. I mean, she was terminated before Dr. Hart. It was, I guess, the same day that Mr. Piercy would have sent the letter to Mr. Hendrick, right? That was September 12th. And Dr. Hart wasn't even terminated that day. I will tell you, and unfortunately it's not in the affidavit, but I will tell you that had there been testimony today, what Ms. Parker would say is that she never made that comment about bankruptcy, that that's just not a true statement. And frankly, Your Honor, even if it was, does that prove aiding and abetting? I mean, it proves that there's bad blood in the office, which there's bad blood in a lot of offices. That doesn't prove any intent to aid and abet. It really doesn't prove anything. In terms of the allegations about her accessing the computers, what she will tell you, what she would have testified to and will at some point, is she wouldn't know how to wipe a computer, that it was common practice at PSGA for people to use their work computers for personal things, that is what she erased, not a single. She would testify, and I believe it's in her affidavit, and we can find it, that she did not access it for any nefarious purpose, did not take any information. There's no evidence that she did, because she didn't do it. Okay. And she didn't take any information. She didn't share any of it with Dr. Hart. The emails and the texts that you see allege that Dr. Hart reached out to somebody, not Miss Parker. Miss Parker is, and it states this in her affidavit as well, she's not hiding from this fact. She's an independent contractor, in essence, if you will, Your Honor. She's a vendor. She's free to work for other people too. That this is part of what she does. She has a right to make a living, especially after being terminated. And as everybody seems to acknowledge, she doesn't have any restrictive covenants against her, not pre-termination, not post-termination. On top of that, Your Honor, there's not a shred of evidence that she had any idea what any contract between Dr. Hart and Dr. Connors said until she got the pleasure of reading it in conjunction with being sued by Dr. Connors, okay, which is now consolidated into this lawsuit. So, you know, she's being held to a standard of helping Dr. Hart breach a fiduciary duty that she wasn't even aware of, and frankly, she didn't do.
Well, let me ask you though, Mr. Foreman, one concern I do have is I think Mr. Hendrick acknowledged that to the extent that he was seeking relief relative to Ms. Parker, Ms. Azar, and Ms. Garvey. It was based on their actions that he believes imply that they did, and particularly Ms. Parker, make efforts to take confidential information and then use it for the benefit of Dr. Hart. And obviously, as I discussed with Mr. Hendrick a moment ago, this is all very preliminary, and discovery may bear out that none of that can all be explained in ways that are not nefarious. But on its face currently, given the, I guess, is there some reason that the court should not enjoin if the court is persuaded by the evidence that Mr. Hendrick presented, is there some reason that the court shouldn't enjoin Ms. Parker from using that confidential information, or otherwise require her to isolate it and return it? Why would that be a burden?
There is a reason, Your Honor, because frankly, that argument, and I don't mind telling this court, I tried to make that same argument in front of Judge Newkirk of this court about 15 years ago, and it failed spectacularly.
Mhm.
Okay. And what I mean by that is this: their argument is basically a no harm, no foul. If she's not doing it, it doesn't hurt her. Well, okay, I'm not doing it. You're not doing it. Miss Brown's not doing it. So, I mean, where does that end?
Well, in fairness, Mr. Foreman, I agree with you, which is why I've indicated I'm not inclined to enter any sort of injunctive relief relative to Ms. Garvey based on the record, or at least the argument that I have in front of me now. But
Right.
I'm saying to you is there is some evidence that Ms. Parker has made some efforts to obtain confidential information to which she was not entitled.
Actually, I would respectfully disagree, Your Honor. What there is evidence of is that she accessed Aetna, and she says as much in her affidavit, for a personal matter having to do, I believe it was with a personal procedure. Okay, there is no evidence that she did it with that she took any information, that she provided any information to Dr. Hart, that she has any information. There is, like you said, it's preliminary. If something comes out to the contrary, Your Honor, I'll be the first one to say then maybe you should enter an injunction against her. But there's none of that right now.
Well, I guess my point is that ultimately that is going to be a mystery that will potentially only be solved with, I guess, metadata from Revance or something like that. But ultimately, it may very well be a matter of credibility of Ms. Parker's testimony as to whether that's what she was doing. And I'm not saying that it is the be all end all that she was in fact engaging in something that was nefarious, but if there is at least some evidence, what is the danger in advising Ms. Parker not to further engage in that behavior and to return any information that is in her possession?
Your Honor, I guess I would answer that with a question, which is, what's the harm in doing exactly with Ms. Parker as you're suggesting to do with Ms. Garvey? We're contending she didn't do it. And we're contending there's no evidence at this point that she did the things she's being accused of. Okay, so if that's the case, again, it goes back to the no harm, no foul argument. This can actually negatively impact Ms. Parker. I mean, let's say she has to go get insurance, for example, or seeks full-time employment somewhere, and then she has to address there's an injunction against her that's improperly placed. So there's potential harm there. And the evidence, if it's this preliminary, look, I think you can do exactly with Ms. Parker as you're doing with Ms. Garvey, which is say, look, I'm not putting it in an order, but you shouldn't do these things. And if I find out that you do, then there will be an order.
Yeah, I understand. Thank you, Mr. Jordan.
Thank you.
I'm Mr. Foreman, I'm sorry.
No worries.
Anything else you want to present, sir?
At this time, no, other than to say, you know, obviously you've seen our briefs. The standard for an injunction, it's considered an extraordinary remedy. I cited Bishop v. Patton 288, Georgia 600. It's a 2011 case. Also the case of Outdoor Advertising Association of Georgia versus Garden Club of Georgia, 272 Georgia 146, which states there must be a vital necessity. That's the language. A vital necessity for the injunction so that one of the parties will not be damaged and without adequate remedy. Your Honor, there's no evidence here to show there's any necessity, let alone a vital one.
Understood. Thank you,
That's
Mr.
all I have at this time, Your Honor.
Thank you. Mr. Barco?
Good afternoon, Your Honor. I suppose what I have to say kind of depends on whether I'm winning also, except with regard to perhaps the information belonging to PSGA.
I
But
think it would
before,
be
yep.
helpful, Mr. Barco, forgive me, but I think it would be helpful to address in some detail from your perspective, Ms. Azar's position relative to what her current. Talk to me a little bit about what she has alleged in her affidavit in terms of refuting what I've heard from Mr. Hendrick in terms of argument about what he believes, other than just the timing, but her association, Ms. Azar's association with Dr. Hart,
Sure.
and that information would be helpful, sir.
Sure. So, very simply, after Ms. Azar resigned from PSGA, she did not go work for Dr. Hart. She's not worked for Dr. Hart. She currently has her own business called Azar Aesthetics. And I heard Mr. Hendrick say, well, all of these companies are functionally, they're functional employees through their businesses. That's not the case here. They are totally separate businesses. This is not in the record, but I'll tell you because I talked to Ms. Azar last night. I asked, how many referrals have you gotten from Dr. Hart since you started? And she said, well, I don't know all of them, obviously, because maybe a patient doesn't tell me. But as far as the ones that I do know, one, since she started her business in November. So that's clearly not some sort of end round on the non-compete or non-solicit provisions that Mr. Hendrick suggested. Ms. Azar has not solicited any patients from PSGA and doesn't intend to. She has not solicited any employees from PSGA and does not intend to. She has not used any PSGA confidential information or alleged trade secrets and does not intend to. She did admit in her affidavit that she took some screenshots of patient information. I think discovery will bear out whether that patient information is confidential information or trade secret information belonging to PSGA. But I don't think that she would have any issue with you enjoining her to return that information, destroy it, as this court suggested.
Forgive me for interrupting you, Mr. Barco, but Mr. Hendrick, am I correct that was your primary request relative to Ms. Azar? Is that a yes? Okay. Okay.
And
Yes, for the
With-
record, since we have a court reporter, sorry, I was on mute.
Thank you, Mr. Hendrick. Mr. Barco.
And just to flesh out the story a bit, so the court has a better understanding, I think a lot of this lawsuit, frankly, is based on some false assumptions about these associations because of the closeness in time of the resignations and the terminations.
Certainly seems that way from Mr. Hendrick's telling of it.
The reality is that, yes, some of these folks were friends. Ms. Parker got terminated. Dr. Hart was terminated. People left in October 2025. Ms. Azar was scheduled to go on a 3-week Italian vacation, as you've heard before.
Hey, y'all, they have internet in Italy. I've been there. They have phones. There's only a 5-hour time difference. Y'all act like nowadays when people take a vacation that they are completely disconnected from the world. And I got news for you. They are not. So
No, she was not.
Okay.
She was not disconnected. But what happened was before she left, if you've read plaintiff's complaint, she ordered extra Botox so PSGA would have this supply of Botox in her absence. This was on, I believe, the morning of October 8th. Dr. Connors was on the text message to the vendor ordering the Botox. It was for PSGA's benefit. It was for Dr. Connors' benefit. And it was a result of her going on vacation. Now, later that afternoon, Dr. Connors approached Ms. Azar and asked her, I guess in light of all the resignations, all the terminations, what Ms. Azar's intention was as to her employment with PSGA. Now, Ms. Azar at that point did not intend to resign that day. However, she had decided that she wanted to leave for the same reasons that Mr. Foreman said that his client decided to resign, which is it was a toxic atmosphere by that point. And you can imagine, we've had this schism between the two doctors. We've heard some stories of infighting. So she had determined already that she would resign, but she just didn't know when. And so when Dr. Connors approached her and kind of forced her hand, she went ahead and told him the truth, which is that she intended to resign. She formally resigned a few days later. I believe she was actually already on vacation when she did formally resign. And then she never returned to PSGA. And at the conclusion of that, she started Azar Aesthetics. She still does laser treatments, skin treatments, and injections as she did at PSGA, but she has no non-compete. So there's this thought that there's this huge conspiracy, and because they left all at the same time, they're obviously going to work for Dr. Hart, and they're all providing Dr. Hart with supplies and confidential information and trade secrets and patients and all this stuff. But that's more coincidence than it is fact. It's more assumptions on Dr. Connor's part, I think, than it is reality. So yes, Ms. Azar has no objection to returning the screenshots that are referenced in her affidavit. We would oppose the motion to the extent there's any other requested relief, and I understand that Mr. Hendrick has seemingly scaled down the requests significantly from the motion.
Often happens once you get into the meat of it.
Yeah, yeah. And so with that, I'll ask if you have any more questions for me.
I do not, Mr. Barco. Thank you.
Thank you.
So, Mr. Piercy, I'd like to hear from you and let you give you an opportunity to respond to all of what that was. But if you can give me about 5 minutes, I'm going to take a quick break, let the court reporter rest her fingers. And I'll be back with you. It's 4:49. I'm going to be back with you at about 4:55. Okay. Thank you.
Thank you.
Thank you.
Thank you all for that brief break. Mr. Piercy?
Yes, Your Honor, thank you. Your Honor, there's no basis on which to enjoin Dr. Hart. She returned whatever PSGA property she had in her possession on September 8th, the last day of her employment. She's not engaging in competitive activities with PSGA within 10 miles of PSGA's office at the Avalon or of the surgical center, C4, which is that Avalon Medical Building a couple miles away. Dr. Hart's office is in Sandy Springs at 5667 Peachtree Dunwoody Road, outside the 10 miles. And frankly,
Questions? Sorry, Mr.
yeah.
Piercy. Two questions on that issue. Number one is, Mr. Hendrick has granted its argument, right? And it is very preliminary, but he has pointed to, alleged solicitations that occurred with patients who live within that 10-mile radius. And so, how do I reconcile? Because you seem to be pointing me to the fact that Dr. Hart's geographic office location is in a place that is geographically 10 miles away from the Avalon location where she previously practiced with Dr. Connors. But what about the geographic patient limitation that's in paragraph 3, as I understand it, and Mr. Hendrick's argument that there at least is some evidence of that?
Okay. Sure, Your Honor. I'll start there and go back up the list. But as to patients, Dr. Hart has not solicited any patients that live within 10 miles. Now, there were patients who contacted PSGA to say, hey, just want to make sure we're on track. I've got this procedure scheduled for whatever. And they're told by PSGA staff, we're going to have to reschedule. Or maybe the practice reached out to the patient and said, we're going to have to reschedule your appointment because Dr. Hart's not going to be working here anymore. Patients in droves start contacting Dr. Hart. Right. This is in between when she receives a letter on September 17 saying you're being terminated for cause at the end of your 15 days. So Dr. Hart does exactly what the practice tells her to do, which is we're going to communicate with patients. You don't say a word to them. We'll handle it. So that's exactly what she did. I mean, biting her tongue, because these are people in her kids' preschool. These are people that she's connected with on social media. These are people that have her cell phone number. They're reaching out. What's going on? I've got this procedure scheduled with you, and they're telling me you don't work here anymore. She didn't say a word to any of them. Her last day was September 30th. After September 30th, she don't work there anymore. She don't have to follow their rules anymore or listen to their crazy directions. She can call whoever she wants. So she responds to those people and says, I don't work there anymore. And in fact, that's exactly what this email says. The email that Mr. Hendrick put up, it's October 1st at 6:04 a.m. because if you think Dr. Hart slept a wink the night of September 30th, she didn't. So did she start calling people, texting people, sending messages to people early in the morning on October 1st? You betcha she did. I just received a message from Dr. Hart that she is no longer with the practice. Not, I got a message from Dr. Hart and she asked for my business. Dr. Hart confirmed what the practice had relayed, like she's not going to be there anymore. After September 1st, Dr. Hart contacts these people. She has a professional obligation. These are her patients. She has a duty to communicate with these people about the continuity of their care. What did she tell them? You can reschedule through that institution, right? She's not soliciting anybody. She's not offering her services. Now, this patient says, I want my money back, and then I'll make a decision about who I want to operate on me, right? There is nothing in here that indicates that Dr. Hart did anything inappropriate. And the same is true with that voicemail, right? A patient leaves.
As I understand Mr. Hendrick's argument about that voicemail, it's primarily the argument that the voicemail itself was sent to people that those phone numbers would be confidential information, presumably belonging to PSGA.
Those patients contact Dr. Hart because they got her cell phone number, because their kids are in the same elementary school, right? So they contact her and they say, what gives? And she's asking the practice, what do you want me to do? What do you want me to do? What do you want me to do? They say, we'll handle it. You don't talk to them. You just show up and do your job until
Hang on.
September 30th.
I'm sorry, Mr. Piercy. Madam Court Reporter, did we lose you?
Yes, I'm so sorry. I dropped off about 2 minutes ago. It kicked me out and
I
rebooted me
saw
back
that we
in.
lost somebody, but I wasn't sure who it was. And the moment I saw you again, I realized it was the court reporter.
Yeah, I'm sorry.
Tell me where we lost you or where you lost us, Miss Young.
He was talking about the services, soliciting her services.
Okay. I think, Mr. Piercy, you were talking about that she had not solicited anyone, and to the extent that she was in communication, that she was no longer an employee.
And that she was responding to
Right.
patients who contacted her. So not her reaching out to them reaching out to her waiting until she was no longer a PSGA employee, then contacting them, but not asking for their business.
And then where we had transitioned to, just when I realized that we had lost the court reporter or that she had rejoined us, was in terms of phone numbers that would have been used to initiate those voicemails, which I don't know, but I think the implication Mr. Hendricks was trying to make is that this was like a robocall that was generated, and that typically requires the input of a list of phone numbers that the presumption would be must have belonged to PSGA. And I think I understood you, Mr. Piercy, to be saying these are responses to reach outs from potential clients or patients, and not indication that Dr. Hart had access to or was using the customer lists of PSGA. And I'll hand it back over to you from there.
Yes, Your Honor, that's right.
Okay.
All right. Okay. Do you have more questions about patients?
No, sir. You directly answered both of those questions. Thank you.
All right, let me then working our way backwards through the list, talk about the solicitation of employees. Dr. Hart is not working with Miss Azar or Mr. Garvey in any capacity. And she is working in some capacity with Tammy Parker. Specifically, Dr. Hart has hired Miss Parker's consulting practice. And that, there's two things that are important about Miss Parker for this particular issue. And one is that she was fired. So the practice can't possibly have some reason to try and keep her around. They didn't want her around. They fired her. But more importantly, even than that, or at least as important, Miss Parker doesn't live within 10 miles of PSGA. And the agreement says non-solicitation of employees, this item 22 shall only apply to employees of the corporation who reside within the restrictive territory set out in 21. And what's the territory set out in 21? 10 miles of the practice or the ambulatory surgical center. She's outside the territory. She's fair game. So, for that reason, there's nothing remotely inappropriate about Dr. Hart engaging Miss Parker. And then just before I shut this down, I just want to again highlight the non-competition piece only comes into effect if shareholder voluntarily terminates. We don't have that. She was fired. Or she was fired for cause. That's the only way the non-competition pops into place, and she wasn't fired for cause. She was fired for pretextual reasons. We've been through that. I won't reiterate it here. I will, though, say that Dr. Hart was not looking to leave in a rush, but she did. Dr. Hart ran out and in a matter of days found an office space that'll do, right? This is not something that's months in the making. I can't believe he just fired me. I gotta go.
I wouldn't worry about spending your time there, Mr. Piercy, because my rather flip remark about the existence of internet in Italy was really what I'm trying to communicate to y'all is that I'm not at all surprised that that could be accomplished in that short a period of time. And so
Okay.
I don't believe that that is outcome determinative today.
All right. All right. Thank you. Okay. She's not competing in the 10 miles. She's not employed anybody who lives within the 10 miles. She's not soliciting patients who live within the 10 miles. She didn't take or copy any documents that relate to PSGA, and she didn't authorize or ask anyone to do it for her. Dr. Hart didn't copy PSGA's marketing materials. She managed PSGA's marketing when she worked there, very social media heavy. Now, with her new practice, she manages her marketing. Surprise, it's very social media heavy. She did it there, she did it here, she started from scratch from both locations. There's no evidence that she took any marketing materials or is using them. Dr. Hart is following her agreements. There's no basis on which to enjoin her from anything. She's not soliciting. She's not competing inappropriately. She's doing exactly what she's supposed to do. And just, I don't have anything else to say on responding to the practice's request for injunctive relief. I don't know if you're wanting me to address anything further about her request for injunctive relief.
I do. This is not only your opportunity to respond to Mr. Hendrick's arguments, but also it's your motion for appointment of a receiver and for injunctive relief on behalf of Dr. Hart. And so this would be your opportunity to make a reply on that issue as well.
Thank you, Your Honor. Dr. Hart seeks not only, I mean, she is suing individually and derivatively on behalf of the company to protect the company. And Dr. Hart, there is evidence, Dr. Connors, there is evidence, is steering money out of the company to his own uses, leaving the company unable to pay its bills. There is the potential for irreparable harm here, particularly given the guarantees in the case. So I just wanted to make that clear.
I understand. What though, some of the conversation I had with Mr. Hendrick was associated with the fact that, I mean, there is a third party medical management group, and presumably they have some fiduciary obligations to the practice, which at this point, I understand the practice takes the position that Dr. Hart is not a shareholder, but putatively, right, she is for the moment. And so why does the existence of that medical management group and other, ethical and fiduciary obligations that would independently exist, not satisfy the concern that you're expressing or that Dr. Hart has about improper financial dealings among and between Dr. Connor's various business enterprises.
Because it's happening even while they're there. And so from Dr. Hart's, her frustration, frankly, is probably not quite as much with them as it is with Dr. Connors, but them as well. And so we're looking for a fresh set of eyes, and the court indicated maybe at least some transparency. That would certainly be appreciated.
What would that look like? I mean, I don't want to make you bid against yourself. But I think I've made it pretty clear that I would not be inclined to grant a receiver under the showing that I've seen currently. But to the extent that the court were inclined to require some disclosure, understanding that any disclosure I might require, I'm certain I'm going to hear from Dr. Hendrick, or excuse me, Mr. Hendrick, who's going to say, well, you're providing them with confidential proprietary business information about the operation of PSGA, and they're going to use that to their benefit from a business perspective. Understanding that universe, what would that look like if the court were inclined to allow you some visibility?
I think it would, at the very least, incorporate monthly accounting records, balance sheets, and profit and loss statements, and transfers between and among C4, Big Green, any other entity that Dr. Connors may have, and whatever compensation Dr. Connors is receiving from the practice, at least during this interim period.
Is that something that Dr. Hart either was provided or had access to on a periodic basis while she was a shareholder and employee of PSGA?
She was supposed to have access to that information. It took a long time. The more she asked and the more she got, the more these issues arose, kind of leading to all of this.
Understood. Okay. Okay. Anything else, Mr. Piercy?
I'm sure I'm missing something, but no.
Okay. Mr. Hendrick, technically you get to have a brief reply, last word on your motion for injunctive relief, although I've kind of let the cat out of the bag in terms of which way I'm leaning and what relief I likely might be willing to provide or not provide. But if you would like an opportunity to have the last word on your motion, this would be your opportunity to do that, sir. And you're muted.
Thank you. It will be incredibly brief, Your Honor. I wasn't quite sure what Mr. Piercy was saying, but it did sound like as of October 1st, he was taking the position that Dr. Hart was free to call anybody and everybody that she wanted to, which concerned me even more than I was when we started this hearing, because the non-solicitation provision certainly is post-termination and would affect her reaching out. The transcript from the voicemail did not indicate that it was a response. It was her reaching out, providing a phone number. If it was in response, she wouldn't have needed to say, here is my phone number. And as I said, it implicates multiple different claims. Her contacting these people evidences that she has their contact information, their patient information. As I said, PSGA has not received a single patient file transfer request for any of these 10 individuals that we identified today. Not one. And so to say that, every single one of these people is on our kids' soccer team, and one, there's no evidence of that. And two, that kind of strains credulity. The
Second
second,
lawyer I've had say that phrase today. It's not one I hear very often. You happen to be the second lawyer that has told me something strange credulity.
the other thing I wanted to point out, we're not taking the position that Tammy Parker lives within 10 miles and therefore soliciting her violated that non-compete. Our argument with respect to Ms. Parker is that Dr. Hart was recruiting her while she was still working at PSGA and while she still had a fiduciary duty to PSGA, and that she was going with her. And so that is our argument, and that's a breach of fiduciary duty. We're not relying on the restrictive covenant there. Mr. Piercy brought up the idea of the existence of these guarantees being a basis to find irreparable harm. Again, that's getting back to monetary claims. And that is really what Dr. Hart's claims are. They are just they're monetary claims. It's how much do you owe me for when I was wearing my employee hat? And I argue that you underpaid me when for my shares. And that's just money. And so you're not entitled to equitable relief just due to money. And you're on where you can be compensated by money.
Hang on, Mr. Hendrick.
Okay. The
This
other
is your
thing.
chance to reply to your request for
Okay.
not to dispute Dr. Hart's claim.
Fair enough, Your Honor. I apologize.
That's okay.
So with respect to ours, I'll kind of start. It sounds like the court is not inclined to grant an injunction as to Ms. Garvey, and we completely understand the court's position with it. I'm not going to waste any time plowing that field. It also sounds like the court is inclined to enter an injunction with respect to Ms. Azar that would be limited to copying the information, returning it. It sounded like Mr. Bardco said his client would likely be amenable to that, so I'm not going to retread that ground either. I think that there is evidence before the court that Ms. Parker may have taken some information with her, was trying to improperly access information through those different portals. I agree with the court that that is something that can be sussed out through discovery, but at this point there is evidence before the court that I think would authorize enjoining her. And also when you look at the evidence with respect to Dr. Hart, I think the quantum of evidence with respect to Dr. Hart is far greater than Parker and Azar even combined. When you look at this with the emails, with the voicemails, with the confirmations of surgeries, with the timing of Ms. Parker's exit. And so based on that, I do think it would be proper to enter an injunction along the lines that I requested with respect to her. I think that unlike Dr. Hart's request here, there is evidence of irreparable harm. That is the most important of the factors. And here you're talking about the loss of patients. You're talking about the loss of goodwill. You're talking about misappropriation of trade secret information. Georgia law is very clear that that ground is ripe, for irreparable harm. Because, even when you look at when you look at her employment agreement, there's a specific provision about patient information that says when you're terminated, you have to turn all that back over. And as Mr. Piercy said, October 1st hit and she was calling anybody and everybody. She was reaching out to everybody, letting them know that she had opened up a new shop and she was open for business. Where'd she get all those people's phone numbers? Because there's nothing in the evidence before the court that says every single person she called was on her kid's soccer team or bumped into them on the playground. The evidence before the court is that she was actively soliciting these people. The transcript from the phone call, the email didn't say she called me back. It said, she called me, what's going on? I want a refund. And so the evidence is that she was soliciting these people. And so that's why we would respectfully request an injunction along the lines of what I articulated at the beginning. And thank you very much, Your Honor, for all the time you've given us on these two motions.
One last question, Mr. Hendrick, and it's to follow up on the presumption I had about what your argument would be if I were to allow some visibility. Two questions. Number one, I asked Mr. Piercy And he said that Dr. Hart had been working on having access to those types of reports, but we began this hearing. I was shown, a series of profit and loss statements, things like that. Are these periodic reports that are provided to Dr. Connors on behalf of MMA about the operation and financial status of PSGA, such that they could be provided in some form with relatively little effort by PSGA and or MMA to Dr. Hart on some sort of periodic basis as well. Understanding that you don't want me to do that, that's not my question. My question is that something that is routinely done by MMA that could be done if the court were to order it?
My understanding is that at the very least, I don't want to overstate what they do, but based on what I've seen, it appears that once a quarter is closed, that they produce quarterly reports.
Mhm.
And there's been talk about, for example, compensation and how being taken too much, just to kind of like a court which to that. There is a compensation agreement. It spells out, in painstaking detail, here is exactly how your compensation is calculated. Exactly. And that compensation is done by the medical management company in conjunction with the accountant. They bring in all the numbers, they go through, they parse it, they
Well,
apply the
me-
formula.
Mr.
Answering your question, yes.
Mr.
Yes,
Hendrick.
they could.
Okay, let me stop you there because again, I don't want to get that far down to the weeds, but what I'm expecting is that a medical management group is in the business of routinely, on some periodic basis, providing reports. Based on what I've seen and how Mr. Piercy characterized those reports would not contain confidential patient data, contact information, or other. Certainly they would contain the financial health information of the PSGA in terms of what it took in, what it's spending. But up until September of 2025, Dr. Hart had visibility on that matter anyway. And so I guess my question is anticipating that argument about that it would be requiring you to provide some sort of proprietary information about PSGA to Dr. Hart, because here's what I'm flirting with. As I think I've said twice now, Dr. Hart is putatively still a shareholder. And if, in fact, she still holds that status unless and until a determination by the court or a voluntary agreement by the parties to liquidate her shares to the benefit of Dr. Connors occurs, then she would be entitled to be aware at least. And I'm not preliminarily finding anything in that regard, but that's sort of what I'm thinking, which is that providing some visibility would provide some reassurances to Dr. Hart about the claims she has made of some sort of financial self-dealing, et cetera. I will say that what I'm anticipating, it might be provided on a more frequent basis if it is the subject of some sort of injunctive order, but ultimately it's the type of information that's going to be produced in discovery anyway, in terms of the value of the contributions and what alleged self-dealings are occurring. So all of that is a very long way of saying this. Here's what I'm going to do, and I would like for the lawyers to please provide me with some proposed orders. Probably, Mr. Hendrick, regarding your request for injunctive relief, you've already stated it. I'm going to restate it for purposes of the record. I am not inclined to grant any injunctive relief as to Ms. Garvey. Although obviously if subsequent evidence is developed as to any of these things and you'd like me to revisit that issue, the court will do so. But based on the argument that I have heard and the representations, right, the good faith representations made by the attorneys, there's nothing to indicate that Ms. Garvey has engaged in the taking or use of proprietary information that belongs to to the medical practice. And so I'm going to deny that motion. As to Ms. Azar, I'm going to grant the motion in the limited sense that it sounds as if you understand, and Mr. Where did he go?
Bartco.
Oh, there he is, Mr. Bartco. Sorry, I have a screen full of people. It took me a moment. As Mr. Bartco had indicated, I'm going to enter an order that requires Ms. Azar to return and or destroy, or both, any documents or confidential patient lists and client information that she took when she left the employ of the medical practice. As to Ms. Parker, I'm going to grant an injunction as to Ms. Parker. I am going to require that she return any confidential proprietary information that she took with her when she left. I am going to require that she certify that she is no longer in possession of any such information, and I'm going to enjoin Ms. Parker from using any such information going forward. As to Dr. Hart, the impression I get is that, and by saying this, I don't mean to imply at this point that I'm necessarily prejudging that Ms. Parker or Dr. Hart have engaged in active wrongdoing or intentional wrongdoing in this regard. That's a matter for some additional evidence. But the impression I get is that Dr. Hart was relying on Ms. Parker's expertise to assist her in sort of starting up her business, and that likely much of what might have been accessed for the benefit of Dr. Hart was likely done not by Dr. Hart. I could be wrong. But I do believe that there is at least some showing based on the factual representations that have been made to me here today that confidential information may have been taken, and that it either could have been taken by Ms. Parker for the benefit of Dr. Hart or by Dr. Hart. I don't know. But because of that, that would not only constitute it would satisfy the basis for injunctive relief, either or both, because of the confidential and proprietary nature of the information in that it belonged to the practice, and or because of the prohibitions in Dr. Hart's employment agreement, specifically whether or not she was fired for cause, and therefore the scope and extent to which those limitations apply to her is an open matter for the court to decide, or for a fact finder to decide based on evidence. But at the end of the day, I do believe that if that provision applies, there is at least some evidence that concerns the court about whether those provisions were violated. And so the injunction that I'm going to grant to the practice and to Dr. Connors as to Dr. Hart is that she return and or destroy, or both, any confidential proprietary information that she has that belongs to the practice, that she certify that she's no longer in possession of any such information, and that would include patient phone number lists, etc. And that she refrained from engaging in any solicitation or competition in violation of the employment agreement. As to Dr. Hart's motion for injunctive relief, and a motion for appointment of a receiver, I think I've already said quite clearly, I'm not persuaded to appoint a receiver. I am also not persuaded that injunctive relief in the form of enjoining the practice from engaging in what appears to be perhaps routine maintenance of debt and other allocation of revenue, but also that is managed by a third-party company that presumably is subject to appropriate professional accounting standards and fiduciary obligations. That I don't believe that the injunctive relief that is sought by Dr. Hart is justified, or most importantly, to Mr. Hendrick's earlier point, I don't believe that Dr. Hart has demonstrated that she would suffer irreparable harm if the court did not grant her some form of injunctive relief or a receiver. And so for that reason, I'm going to deny both of those motions. However, as I think I've basically already made clear, I think that it would be produced in discovery anyway, and that it will go a long way, I think, toward alleviating some of Dr. Hart's concerns, because presumably, not to imply that there has been any nefarious self-dealing, but if you know that those transactions are going to go on a report and be provided to someone who is concerned that you're making those transactions, presumably that would limit your inclination to engage in such behavior. And so, Mr. Hendrick, I'm going to ask you, because I've largely ruled in your favor, I'm going to ask you to prepare that order. I am going to ask you to work with Mr. Piercy to determine how we're going to define or describe the nature of the report or reports that will be provided and on what periodic basis they are provided to Dr. Hart. Quarterly would be at a minimum what I would expect. Monthly, if it's not an overburden, is the universe of what I'd like you guys to consider. And if you can agree on what that scope looks like, then provide me with a proposed order along the lines of what I've just outlined. That would be very helpful. Mr. Piercy, any questions regarding what I've just outlined in terms of my ruling?
Just one, and that is, it is the continued involvement of a third party practice management company part of the order?
I am not.
Okay, I'm just trying to be clear.
It is not, in the sense that I think that would be a bridge too far for the court in terms of inserting itself into the operations of the medical practice. But what I am saying is that my understanding is that, to the extent I'm ordering a report to be produced, number one, it is a report that would typically be produced by MMA. That's number one. And number two, as I think I've said before during the hearing, one, the existence of that medical management group gives the court some assurances, because they are governed by professional accounting standards and fiduciary obligations, that it does give the court some assurances about that I think mitigate the need for a receiver. And so that's why I mentioned the medical management group. I am not inserting myself to require that it be provided. But of course, if you tell me that instead of getting a report from MMA, that instead you got something written in crayon by Dr. Connors, that's going to be a real problem. And I'm not sure it's going to satisfy the order that I'm entering.
Understood. Thank you.
Okay. Anything else, Mr. Hendrick, in terms of what I have ruled and what my order is?
Just for clarity, because the Dr. Hart, I'm going to call them competing practices, are parties and we're subject to that. And so
Yes,
they would be part of the injunctive relief as well.
Right, which is why I am prohibiting both the use of proprietary information and also the violation of the shareholder agreements, and one or both of those would apply to any corporate alter ego of Dr. Hart.
Okay, thank you, Your Honor.
Okay. Now, anything else the parties want me to address? Obviously, I'm aware we have a motion to dismiss. You're not technically entitled to a hearing on your motion to dismiss. It also seems like a relatively closed universe problem. But we are all here. So what shall we do next, Mr. Hendrick? I believe it was your motion to dismiss Dr. Hart's derivative claim. As I understand those motions, your argument was that that Dr. Hart has no standing because she's no longer a shareholder. Mr. Piercy's argument was she technically is still a shareholder until she agrees to a buyout or Judge Krause says she's no longer a shareholder by operation of law. That's sort of what I understand the issue to be. Please educate me if that's not right.
Yes, Your Honor, we had multiple arguments. One was she's not a shareholder. And she has to be a shareholder throughout the continuation of the suit. And our position is she is not. And therefore she doesn't have standing. Then there are some statutory prerequisites. Number one, that a shareholder derivative demand letter has to be sent. It was not.
Right?
You have to wait 90 days. They did not. There are two exceptions to it. One, the company has to reject the demand letter. There was no, Nick, if you're still on, if you could just put up our response letter very, very quickly. So opposing counsel's contention is that the September 12th letter that he sent, in fact, Nick, if you'd pull up the September 12th letter from opposing counsel very briefly and scroll down to the list of demands in there, because when this was originally filed with the court, it was heavily redacted. And, I will say that I have received derivative shareholder demand letters and I have served them, and this just is not one of them. It has to talk about action that you want the company to take in response to allegations that a shareholder is bringing. This is a demand letter for payment and for Dr. Hart to go.
Right, I understand. And so, but I don't want to get too far into the weeds because what I understand your position to be is that Mr. Piercy's going to tell me that he believes that was the derivative demand letter, fix the problem, corporation. And if you don't, then I'm authorized to sue on behalf of the corporation.
But there is no fix the problem here. It is pay us a bunch of money and we're leaving. If
Well,
you
she
look,
might think that would fix the problem.
well, in Your Honor, okay, so you've got to wait 90 days, and one of the exceptions is that the company has to reject the derivative demand. And Nick, if you would bring up our response, and so the company, by statute, the company has to reject the demand. In the first, this is what opposing counsel contends is the corporate rejection. The first two sentences, Holland and Knight, we represent Dr. Connors. We understand that PSGA is represented by Albert Leibovitz. I'm sure I destroyed his name. Apologies to Albert, who we have copied on this letter. So this letter wasn't even sent on behalf of the corporation. In fact, it expressly says we're not representing the corporation with respect to this letter. We're representing Dr. Connors. So there's no way that this letter constitutes a rejection by the company.
Okay.
And so then the other one is that you have to have irreparable harm if you don't file this lawsuit. And Your Honor, if you look at the evidence that we put before you already, everything that Dr. Hart is complaining about, that her characterization is off, but the money, that the allocation of payments for expenses between the companies, she had known about that since before she even bought in. She waited a year, 15 months after learning about it to file a lawsuit. Georgia law is clear that irreparable harm connotes something imminent and that you have to act quickly to solve. There is nothing that has changed recently that makes this imminent irreparable harm. If you look at her complaint, Your Honor, she says that she finally was provided, and we dispute it, but if you just go by her complaint, she says, I finally received documentation, I believe it was like summer or by latest December 2024. And then you saw emails where she's saying, I've been going through all the company documents. She had known all about this information for almost a year before she even filed this lawsuit. And she didn't do anything. There was no fire for a year, but now they're going to take the position that they couldn't wait 90 days. And Your Honor, one last thing that I want to point out, and I don't know if this is something that opposing counsel has thought about. I don't know. Most of the claims that he brought derivatively were seeking injunctive relief. You have denied that. You've said that we have to provide certain financial information. I will represent to the court that even if we're not going to challenge that, even if the derivative claims go away, okay? If these derivative claims do not go away, then the company is required, traditionally the way this works is you have a special litigation committee that performs an investigation. The lawsuit and discovery in the lawsuit is stayed during that period, at which time the special litigation committee makes a recommendation under the business judgment rule as to whether or not it would be in the best interest of the company to pursue the claims against, in this case, it would be Dr. Connors. In opposing counsel's motion, it's somewhat ironic because he says that this motion to dismiss was filed presumably to try to stall discovery. But the practical reality of the situation is, if these derivative claims don't go away, we're going to be filing a motion to stay during the pendency of the corporation's investigation, which is how every single derivative, that is how derivative cases work. The company's entitled to investigate those claims, make a determination, file, if they decide it's not in the best interest of the company, they file a motion to dismiss that's usually supported by a report and recommendation from the Special Litigation Committee. And at that time, you litigate that. And Dr. Hart's claims here are about money. And the question is, does she really want to spend the next however many months with all this stayed so that the corporation can decide whether or not it wants to pursue these claims against Dr. Connors? I think that is going to frustrate everybody involved in this lawsuit and is not going to help Dr. Hart achieve what she really wants, which is employment compensation and money for her shares. And that's not part of a derivative claim.
Mr. Hendrick, I feel like that last part, while it is quite compelling, is really a discussion for you and Mr. Piercy, not necessarily me. I would like to hear from Mr. Piercy, though, in terms of his substantive legal response to the motion to dismiss.
Your Honor, actually, I'll be addressing the motion to dismiss, if that's okay.
Mr. Khan, okay.
Unless you'd rather hear from Mr. Piercy, I don't know.
Oh, I'm happy to hear from new and different people. I'm trying to figure out why I'm sitting in the dark, y'all. I apologize. I know it looks that way, but normally the sun is shining on me, and y'all have kept me here after dark. So go ahead, Mr. Khan.
Thank you, Your Honor. So I'll address each of those arguments one by one. But first, I want to highlight the standard. The pleading standard is exceedingly light, especially in state court.
To dismiss I'm not going to reach out and dismiss anything that I absolutely should not do, sir.
Exactly. And I think Mr. Hendrick's analogy to the court's ruling on injunctive relief is completely inapposite because the standards and the burdens are completely different. Whether the derivative claim should survive a motion to dismiss has nothing to do with whether we proved our entitlement to injunctive relief at this stage. All that matters is whether we pled enough in our complaint to go forward on a derivative claim, which we have. The first issue is the demand letter. First of all, we allege that we did send a demand letter. They cannot, by their response, convert our demand letter into something different. Their response does not control. I don't care that their response says it's from Dr. Connors and not from the company, even though he's the only other shareholder, and this is a two shareholder company and not a publicly traded company or anything like that. This is a very small, closely held business. But the demand letter itself is addressed to John P. Connors, MD, at Plastic Surgery Group of Atlanta. The subject line is re Plastic Surgery Group of Atlanta, PC, and it specifically outlines the misconduct that we are alleging, and it specifically states that if the demand is not met, Dr. Hart will pursue both direct and derivative claims. It expressly states that Dr. Hart will bring derivative claims if the demand is not met. So let's now go to what the statute actually requires. Not much. OCGA 14-2-7421 requires only this: a written demand, we have that, has been made upon the corporation, we have that, to take suitable action. That's it. We don't have to demand an investigation. I know a lot of the time that usually happens, especially with publicly traded companies or large companies, but investigation is not required.
Question though, Mr. Khan, what if, even if you didn't ask for an investigation, what if the appropriate, to Mr. Hendrick's last point, which I really think is a matter of negotiation between y'all, right? But what if the answer by the corporation is, well, in order to address this letter, we have to do an investigation. And if we do that, you have to stay any and all litigation while we figure that out. What of that, in terms of the corporation's right to do an investigation if it chooses?
Well, the corporation, with or without a stay, has the right to do whatever it wants with respect to an investigation. The statute gives them 90 days of breathing room before a complaint is filed, unless two exceptions are met, and I'll get to that. But normally, all the statute gives them is the right to 90 days. It does not give them a stay. If they decide to do an investigation, it doesn't give them the right to stay for the duration of litigation. Sometimes that's negotiated. But I didn't hear Mr. Hendricks cite any statute or any legal basis for a stay, other than that this is how it's usually done. And what he omitted is that's how it's usually done, not legally required, how it's usually done with publicly traded companies or very large, closely held companies, not smaller, two-shareholder, closely held companies. But the statute only gives them 90 days to do whatever they want to address the demand, unless it is either rejected or irreparable injury to the corporation would result by waiting for the expiration of the 90-day period. And again, we are in pleading land. We are under the pleading standard. We have addressed both of those in our complaint. First, the firing of Dr. Hart was effectively a rejection. We sent a demand saying, hey, here's how we want to work out these issues. And their response was, you're fired. In all practical sense, that is a rejection. There was no, let's talk about this. There was no, we're going to have a mediation, or we're going to discuss any of these points, or we're going to do anything to address your letter. The communication was, you are fired. And that's it. And not only you're fired for cause, for made up cause reasons, so we can devalue your shares at zero. That's a rejection. On top of that, as a second way to get around the 90 days, which, by the way, 90 days at this point have already passed since we sent our September 12th letter, so it'd be kind of useless to wait another 90 days, would irreparable injury to the corporation result by waiting? Now, I understand that for purposes of preliminary injunctive relief, the court has said that there is not irreparable injury, but for purposes of the pleading standard, we have pled enough to show that there would be irreparable injury to the corporation, not just to Dr. Hart financially, but irreparable injury to the corporation, because we have alleged that there is continuing self-dealing, that there is continuing transactions exceeding $10,000 that required Dr. Hart's approval that was never sought, that there is continuing depletion of the company's assets that could lead it eventually to significantly devalue the company, irreparably devalue the company, or have it eventually reach insolvency. At this point now, where the court has to take our allegations as true and all reasonable inferences from those allegations as true and construe them in the light most favorable to us, we have pled enough to show that there would be irreparable harm had we waited 90 days at the way, especially after that, the response to our letter, which is fired for cause, that's it, we're not talking to you. As I will say it again, especially at the pleading stage, that is enough to meet that procedural requirement to file a derivative claim. Then there's the question of, is she still a shareholder? Everyone agrees you have to be a shareholder to pursue a derivative claim. There's no disagreement about that. We have pled enough in our complaint to show.
Save you trouble on that one. I think I've said that 3 times, at least for now. If I deny them, or excuse me, if I were to grant the motion to dismiss, it's not going to be on the basis that as a matter of law, Dr. Hart is not a shareholder. So.
Then I'll move right along. And then on the last point that Mr. Hendrick made was about this committee and stay. That is, I think, a misguided practical reason to say why he thinks Dr. Hart should not pursue these claims. We think otherwise, but that is not a legal basis to dismiss the claims, either derivative claims or direct claims. And if they file a motion to stay later on, we'll address that then. But as of now, the only pending motion is a motion to dismiss for failure to state a claim. We have stated a claim, and that additional consideration that Mr. Hendrick thinks is important is not a valid consideration as to whether we have stated a valid claim.
Thank you, Mr. Khan. I appreciate
Thank
that. Mr. Hendrick, your response?
Very, very briefly. Number one, their allegations really don't matter with respect to their derivative demand letter and our response. And the reason for that is because they attach the derivative demand letter and the response to the pleading. And when you attach an exhibit to a pleading, to the extent that the pleading is inconsistent with the allegations in the complaint, the pleading governs. And so that's number one, Your Honor. And I will point you to some case law that stands for that proposition. The principle is codified in OCGA section 91110C and has been consistently applied by the Georgia Supreme Court and the Court of Appeals for over 6 decades. If you look at the Georgia Supreme Court in H&R Block Inc. versus Asher, says where a party relies on a written instrument is the basis of an action and attaches a copy of the instrument as an exhibit, the facts shown in the exhibit will prevail over the allegations of the party in the pleading. So it doesn't matter. Moreover, for them to say that we sent them a derivative demand letter, whether or not a letter satisfies statutory requirements is a question of law. And so the fact that they've said this qualifies, the court doesn't have to accept that as gospel at the pleading stage either. So at this point, our position, and I think it's the correct one, is that the court has to look at the letter they sent and our response. And as a matter of law, say, is this a derivative demand letter? Does this satisfy the statutory requirements? And then you have to look at, if the court says yes, then they've got to qualify for one of the 2 exceptions, because it is undisputed that they did not wait 90 days before they filed the complaint. You can tell that from the pleadings because they attached the letter and they only waited like 2 weeks, 14 days, I think, before they filed the complaint. So they were nowhere close to the 90 days. So then the court has to look at the response letter, and the statute says the corporation has to reject it. And you look at that and you say, as a matter of law, is this a rejection by the corporation? Which, by the way, they don't allege in their complaint. Opposing counsel has said, you got to look at the allegations of the complaint, Your Honor. Okay, let's look at the allegations of the complaint. They don't allege in the complaint that that letter constituted a rejection on behalf of the corporation. Rather, what they say is that the letter evidenced that it would be futile to wait 90 days. But as we pointed out in our motion to dismiss, it is well established under Georgia law that there is no futility doctrine with respect to this 90-day requirement. So there's absolutely no allegation in their complaint that the letter constituted a rejection by the company, nor does the letter say that it was sent on behalf of the company. So they should not be allowed to avail themselves of that first exception. And then you have to look at irreparable harm. And when you look at the allegations in the complaint, what the allegations show is that she was provided with this information in 2024. And then she waited until September of 2025 to file a lawsuit. So how can you say that there was irreparable harm due to the discovery of information in December of 2024 that was so grave that having waited 9 months to begin with, you can't wait another 90 days?
I'm going to stop you there because I've already heard the irreparable harm aspect. Anything else you want to add to your reply, sir?
Well, the one other thing I wanted to address, Your Honor, and the reason why I raised it, I know the last point that one other thing, when he talked about the flippant response to the derivative demand letter and how we didn't address the demand to the corporation, the reason why we did not address the demand for the corporation was because when I read it, at no point did I think that is a derivative demand letter sent under the statute at all. And we weren't responding on behalf of the company. We were responding on behalf of Dr. Connors. And to the extent that it was construed as a derivative demand letter, then the company, which in our letter we say is represented by someone else, would have had 90 days to respond to it. And our letter was sent only 5 days later. So we would have had...
Mr.
Yeah.
Hendrick, is this not something, I mean, there's a motion pending and the court will deal with it as necessary, but I mean, is this not something that is easily remedied by an amendment?
to their, well, no, Your Honor, you can't, in fact, you can't, and there's a case on point.
Other than the delay that might be occasioned by it, but go ahead.
Well, my point, Your Honor, is they would have their claims. There's case law that says their claims have to be dismissed. If they fail to satisfy these procedural requirements, it has to be dismissed. If you look at Pinnacle Benning LLC versus Clark Realty Capital LLC, 314 Georgia App 609, it's a 2012 case. And what it says, accordingly, having already filed a complaint that admitted to non-compliance with the demand requirement, Pinnacle could not cure this procedural defect by later sending a demand letter. It is a condition precedent to filing suit. They would have to dismiss and refile.
I don't disagree with you. I guess maybe amendment is an inartful way to say it, but it doesn't seem to me, given the recency of these events. Even if the court is inclined to dismiss, and dismissal is what is in fact required, it seems as if this doesn't put that issue to bed. It's just a matter of time for it to be perfected and perhaps rebrought, particularly given the fact that the state of Georgia allows you to amend your complaint with, essentially, other than adding parties, et cetera, and widely. Here's my inclination is that I want to look at the letter and the response letter in some greater detail and see what I think about it. As I had already told Mr. Khan, there's no universe in which I'm going to grant the motion to dismiss because Dr. Hart is not a shareholder. Whether or not I grant a dismissal on the basis that the demand procedure wasn't followed properly is a closer question, primarily because, right, wrong, or otherwise, those letters, even if Mr. Hendrick, even if you're right that I can look at those letters and determine whether they satisfy the statute, I wonder if, given the context that the court is lacking in those letters, that it might be a better issue for a summary judgment motion rather than a dismissal. I'm not ruling that right now. I'm just telling you that's sort of what my thought process is currently on the motion to dismiss. And that's where we're going to leave that issue for now. I will give you a ruling. Likely it will be by email, and I will just say this is going to be my ruling, or actually Mr. Freehoff will say this is going to be Judge Krause's ruling. And then we'll go from there on that issue. I have one other sort of procedural case management matter to take up with you guys. It'll be very brief. Is there anything else the parties need from me, or any other matter or motion that is ripe that I've not? I'm aware that there's a motion to supplement a complaint, but it's not nearly ripe at this point. And so I think we've done everything we needed to do today. Mr. Hendrick?
There's two issues, Your Honor. One is very, very quick that I think we can dispose of. And then there is another motion to dismiss that was filed by Garvey and Azar. The very, very quick matter is that yesterday, Dr. Hart's counsel filed a motion to strike. I know it's not right, but if you'll give me 30 seconds, that had to do with the filing of a document that contained some patients' names. He could have saved his client the cost of preparing the motion and the filing fee by emailing me or calling me. We will provide the court with a proposed order. It was supposed to be redacted. The unredacted version accidentally was filed. We did not realize it until that motion was filed. We will just provide the court with a proposed order directing the clerk to strike it and allow us to supplement with a redacted version and take care of that. It was, like I said, the unredacted version was filed instead of the redacted version. We're very sorry for that, but in the future, an email or a phone call, and we can take care of that. We don't need to spend money filing those motions. We'll just provide you with a proposed order.
Okay. On that note, I don't have any record of that motion having been filed, so it hasn't been accepted. And at first I thought, oh, maybe it was filed in the Dr. Connors maybe it was filed in the other matter under which we are not proceeding, but the most recent filing I have in one of these cases is December 30th, and the other one, the most recent filing is January the 5th. So I don't have that motion, but it sounds as if the parties can agree and we'll take up some remedy. As I mentioned earlier, although I did let the parties argue it a little bit, you're not really entitled to a hearing on a motion to dismiss. And so
Your Honor, if I may, Jordan Foreman here for, for Ms. Parker and Ms. Carvey. If I can just have a minute or two of the court's time to address the motion that we
Yes.
filed, and I'll start by saying, look, obviously, the court has ruled in favor of injunctive relief against Ms. Parker, and I understand that. And so I don't think I can argue a dismissal against somebody that has had an injunction entered against them. So I will not do that. But I would like to just take a minute to talk about Ms. Carvey and the potential for a dismissal here in the motion. It'll take 2 minutes.
okay.
Thank you, Your Honor. So I'm not going to argue about the standard of dismissal. We know what it is. We're not technically under the Supreme Court, the Ashcroft v. Iqbal, Bell Atlantic versus Twombly decisions, but there is a decision in Georgia, Mabra versus SF Inc. And I'll find the site. I had it here. I can find it for you, but and I think it's a 2012. It's 2012. And it also cites to a U.S. Supreme Court case, by the way, Papasan versus Elaine, 478 U.S. 265, 1986. And what Mabra says, and it's still good law, in the absence of any specifically pled facts to support what amounted to a legal conclusion couched as fact, the trial court was not required to accept this, meaning a fact, is true. And so I've culled through the complaint, and here's what I see as being the allegations against Ms. Carvey. And there's 4 of them, and I'll address each one. She resigned. That's one. She used computer equipment. She conspired, and she tortiously interfered. Okay, so those are the 4 allegations that, if you're really summing it up, that I see against Ms. Carvey in this complaint. Let me start with the last 2. They're legal conclusions, Your Honor. Conspiracy, you have to state some kind of predicate fact. It's not there. Same thing with the tortious interference. So you can't just say she tortiously interfered. There has to be some fact to back it up. Again, while I may respectfully disagree with the ruling against Ms. Parker, at least a fact was raised about the computer use. Okay. And again,
I agree with you, Mr. Foreman, and here's why. I think that the distinction here is that was for purposes, that was some evidence to support the factual allegations against Ms. Parker. I've not heard any evidence, which is why I denied the motion relative to Ms. Carvey, but that doesn't mean that within the 4 corners of the complaint, there is not evidence that might be developed that could demonstrate that Ms. Carvey engaged in the factual behavior that's alleged.
I don't think there is, though, Your Honor. That's the concern. Because again, I've just recited to you the 4 things that are named. 2 of them are absolutely legal conclusions. To say somebody was part of a conspiracy is not a fact. That's a legal conclusion. To say that somebody tortiously interfered is not a fact. It's a legal conclusion. The fact that she resigned doesn't even really make out an element of anything, not even the aiding and abetting thing. It doesn't add anything. And the fact that she used equipment, that's not even raised in the conversion claim that's cited, Your Honor. So I don't see any facts recited that satisfy elements of any of the claims raised against Ms. Carvey.
Okay. Let me, Mr. Hendrick, I'm going to save you the trouble of making argument on this. And that is that everything I just said a second ago, Mr. Foreman, I think it, based on the legal standard that applies, I think it defeats your motion to dismiss Ms. Carvey. Having said that, however, I think it is incumbent upon good faith litigators not to drag a party who really ought not be a party through the ringer of having to pay attorneys and having to be involved in ongoing litigation when there really is not the development of factual evidence indicating that person's involvement. And so really my request, Mr. Hendrick, would be perhaps that the court might be willing as the course of discovery develops, very preliminarily, the court might be willing to consider a very preliminary motion for summary judgment absent the development of some evidence as to Ms. Garvey's involvement. Because again, I don't want to see someone who the preliminary information is may not actively be involved in this get drugged down this road with all the rest of us if that's not what ought to happen. Having said that, however, legally, I believe that you have alleged facts from which there could be developed evidence demonstrating that those rose to the level of the alleged causes of action that have been asserted against Ms. Garvey. And so I'm going to deny the motion to dismiss on that basis.
Thank you, Your Honor.
Anything,
Okay.
Mr. Foreman?
That's it, Your Honor. No.
Okay,
Thanks.
anybody else? Okay. So the only other thing I wanted to discuss with you guys is I have a fairly detailed case management order that I use in cases like this because I'm also on the business court. And so on the business court, we do a lot. If any of y'all have litigated in the Metro Atlanta Business Court, I'll be seeing more of you. But I have a fairly involved case management scheduling order that requires you guys to really get down into the detail of what your deposition schedule is going to look like. And it gives you some idea of how I would like for you to conduct yourselves in terms of submitting things to me. And it sets hard deadlines in a table form. I'll email it to you guys so you can fill it out. But some of them may not be relevant for y'all, but it includes things like deadlines for services of written discovery, fact witness disclosures, depositions of fact witnesses, experts, etc. And then it gives you some guidance about when and how we will schedule a trial and pretrial conferences and that sort of thing. The idea is for y'all to hash that out once I've dealt with preliminary dispositive motions, which I've pretty much now dealt with, except for the one related to the shareholder derivative clause claim. But once I give you a definitive ruling on that tomorrow, Mr. Freehoff is going to email you a proposed case management order and a scheduling order. It doesn't have any dates in it. The idea is for y'all to get together and put in dates that the parties believe are reasonable. And then to the extent the parties have questions, what I typically do with cases like this is actually schedule like a 30-minute case management scheduling conference so that we can hash these dates all out. Most of it, I suspect you will have already agreed to. And to the extent that you don't agree to them, I will tell you, well, I'm saying we're going to do it this way or we're going to do it that way. It will likely be it will at least be, I'll email this to you tomorrow, and the scheduling conference would likely be towards the end of the month. So you'd have a good 20-ish days to take a look at this and figure out if y'all can come to some agreement. Any questions about that procedure, Mr. Piercy?
No, Your Honor.
Mr. Hendrick?
No, Your Honor. Thank you.
Mr. Foreman?
No, Your Honor.
Mr. Bartko?
No, Your Honor.
Okay, I think we're done for the day then. Thank you all very much. I appreciate your educating me on this, and I look forward to working with you guys as the case goes forward. I will look for those proposed orders, Mr. Hendrick and Mr. Piercy. Not a super hard deadline, but realistically, while it's fresh, if you can get it to me by end of next week, I think that would be ideal. And if you can't, if there's some reason, let me know. I understand that things happen, but I would like it sooner rather than later, and ideally by the end of next week. Okay?
Yes, Your Honor.
Thank you all. Have a good evening.
Thank you, Your Honor.